What have reached your lordship? 10/4 I filed. Today is 15.
I had granted you 7 days.
7 days.
I will wait for 7 days.
Your lordship is correct over there. I don't know. Friday, my clerk party chair.
Let me do one thing. Let me pronounce the judgment. I'm not going to go back from that.
No. I just.
If you find that if some of your contentions have not been taken into account, then
No.
I don't think it may be necessary. Okay, let us see.
Pardon to mention,
Yes.
entry order continues.
I think see, return note of the in that case. Yes, Mr. Das. That is item number item 2. Suril Kumar Bej, I think yes, there was a return note. I think there was a return note.
Then 10/4 I filed. I was
The other side had also, the state government had not filed.
No.
I think you had filed. So that is there.
I have filed. I have served copy of.
Yes, that has been taken.
Entry order continues since 2017, my lord.
Yes.
I am for the opposite party, post of Anganwadi helper, my lord.
What the
Anticipated tide of metals.
Tied matter, don't mention.
It is TRPC matter. I am for wife. And since 2023, it is pending. 23. Sorry.
Siddha the source
And the wife is living in Nabrangpur.
them.
May I please, lordship, tied up matter 4389 2024. The earlier disposal, lordship, 9/1/2024. Tag up.
My lord, petitioner is appointed TG scale. Petitioner 2 months retired college.
देखो ना रिटायर कर जो जी देखो
Pardon to mentioning, my lord. My lord, on BLAPL number 12452 of 2022, my lord. Well, in this case, I have filed an IA for the interim bail on the ground that my lord, petitioner has suffering from. Lordship directed to list the order 15th.
see the list is now quite a bit of a lot of matters are here, so naturally
Equal to opponent surgery, my lord.
I know
My lord.
I will see what can be done.
May we pardon?
Yes, Mr. Pradhan.
This is an item 56 in the weekly list. Bail matter.
Item 56.
Yes.
Sorry, weekly list.
I will not be available after lunch. May I pray if it can be taken up as the first item or any time before 12 o'clock?
This is that matter where it was heard for some time.
Yes.
I think other side is CBI.
Other side is below state.
State.
And informant is also appeared.
What is the brief? That 2.86 crores. 14.86 जो लिखी थले
Right.
district judge how? I think we heard it.
Yes.
Why was it kept pending?
With regard to as to from how what was the amount that has been paid and on what basis the order reflects.
So you want the matter to be taken up as the first case?
Yes.
You are ready?
Yes, my lord.
I don't know. One case will take it up.
My lord, today's item 26, today's list, my lord.
Yes.
I can taken next week.
26.
Yes, ma'am. I'm for the opposite party.
Used for the petitioner?
The petitioner for Mr. Ajit Kumar.
Ajit Kumar Mate. Have you taken his consent, sir?
No, my lord. Actually, I don't know filed some message.
I'm willing to grant you adjournment.
He can mention at the time of hearing, but
You can, because he's not there.
my file is not there. That's why I.
It's all right. I will adjourn it. Don't worry, I'll adjourn. But if you have not mentioned, you have not taken his consent, it will not be proper.
I will.
Yes.
Yeah.
Supplementary list item number for judgment.
This court therefore finds that the petitioner has made out a good case for interference by this court. The writ application is allowed. The impugned order under Annexation 3 is hereby set aside. The CTPO Muribahal is directed to issue necessary order of engagement in favor of the petitioner as Anganwadi worker of Dunguri Guda Additional Anganwadi Center without any further delay, and in any case within 2 months from the date of communication of this order or on production of certified copy by the petitioner.
Item number 2 for judgment.
In the result, the writ application is allowed in part. The opposite party authorities are directed to disburse the arrear salary / remuneration of the petitioner as admissible from the period from 16/9/2008 till 11/9/2011 within a period of 2 months from the date of communication of this order or on production of the certified copy thereof by the petitioner. If you are wondering what is that date, 16/9/2008, that is for the date of judgment, date of order, earlier database. I have held that you did not acquire any right prior to that. Whatever. Rightly, wrongly, I think your note has been taken to. Yes.
Item number 3 for judgment.
In the result, the writ application is allowed. The impugn order under annexure 8 is hereby quashed. The opposite party authorities, particularly opposite party number 2, is directed to engage the petitioner against the available vacancy in any equivalent post, subject to the condition of his acquiring TET qualification within a stipulated period. Necessary orders in this regard should be passed as early as possible, preferably within a period of 3 months. I've gone through the notification governing the appointment of Sikha Sahib. There is a reference to section 23(2) of this act,
Right.
along with the rider that untrained candidates can be appointed subject to the condition that they have to clear the TET examination subsequently within a specified date, whenever it is held. Yes.
Now 4 for judgment.
For the foregoing reasons, therefore, the bail applications are allowed. Let the bail applications. Oh, are allowed. Let the petitioners be released on bail on such terms and conditions as the court below may deem fit and proper to impose, including the following conditions. They shall appear before the IAC of Southern Kunta Police Station on every Sunday at 10 AM for a period of 6 months, and such fact shall be certified by the IO to this special court once in every fortnight. They shall personally appear before the court below on each date of posting of the case, and no representation through counsel shall be allowed under any circumstances. They shall not commit similar or any other offence. The question is, Mr. Mishra, if those witnesses gave their statements on 24/5, you could have sought for their remand. Why did you wait till they came out from the jail to arrest them? That gives away.
And
That is a
also-
giveaway, huge giveaway.
And also on the basis of that independent witness statement, they were arrested.
Nothing is there.
But they are drug peddlers.
They are comfortless. Yes, I have held in my. You please read that judgment. I have held that they may be guilty, may not be guilty. But rule of law, how can you ignore it?
Yes, yes.
Once that goes, it will become a police state. Madam, just they waited for 2 days. The IO waited for 2 days. Just as he came out from the jail gate, nabbed him.
They have also shown in the arrest memo that they have arrested from in front of the jail.
Item number 5 for judgment.
The bail application is therefore allowed and disposed of with the direction that the petitioners, despite addition of offence under section 307 of IPC, shall continue to remain on bail as granted by this court earlier, subject to the conditions already enforced.
Item number 6 for judgment.
These are different matters. That is different, completely different. Nevertheless, I am just reading out the film. An order of NBW having already been passed, it would be in the ends of justice if the petitioner surrenders before the court below and moves for regular bail. As already stated, there being nothing on record to take an adverse view against the petitioners, even upon addition of the graver offences, it is directed that on their surrender, the court below shall release them on bail on such terms and conditions as it may deem fit and proper. You will get them after correction.
Item number 7 for judgment.
Again, this is completely different. Having regard to the nature of accusations and materials on record, I am not inclined to grant anticipatory bail to the petitioner. The ABL appeal is however disposed of, granting liberty to the petitioner to appear before the court below and to move for bail, which shall be disposed of on the same day in the first hour. In case of rejection, it shall be open to the petitioner to move the higher forum on the same day, for which the records, including the case diary, shall be transmitted at his cost. The higher forum shall also dispose of the bail application on the same day.
Item number 8 for judgment.
Again, this is completely different. In view of what has been stated here and before, this court holds that the anticipatory bail application is not material. However, a summons having been issued by the court below, the ABL appeal is disposed of, granting liberty to the petitioner to appear before the court below and move for bail, which shall be disposed of on the same day in the first hour. In case of rejection, it shall be open to the petitioner to move the higher forum on the same day, for which the records, including the case diary, shall be transmitted at his cost. The higher forum shall also dispose of the bail application on the same day. Shati, item 8 kala. Weekly list of
Weekly list item number 56.
56 to
Before proceeding, my lord. In the item number 1, 2, 3, all the writ petitions are allowed, my lord. And my lord, may I pray, my lord, that the time stipulation may be calculated from the date of production of the certificate.
Can I do it? No, no, I will no rejection to stated the 2.76 crores in the company of the accused, they returned the amount to be less 14.86 lakhs. You were required to file an affidavit?
Yes, Your Lordship, we have already filed and served a copy.
You have filed an affidavit.
Last occasion, Your Lordship.
Right. You are Purna Chandra Rathore?
Yes.
You are Purna Chandra Rathore?
Yes, it's the informant, yes.
Yes. What is your contention?
Affidavit file is Sarmista about
How about affidavit of still? Who is Purna Chandra Rathore?
Chari Chobis.
Yes, yes, I got it. No, see the soul ek 24 There are many affidavits. Flag L. You are referring to probably the one in the flag L.
Last one.
Last one is answer. You have a copy of the affidavit which you have filed? Yes.
Lordship, sorry, Your Lordship, I don't have actually the matter is checking as the first matter.
Achha. Oh, he was not informed.
From London senior is not able to appear before. Lordship.
You ask him to come. I'm passing it over 2-3 matters. What do you say? Huh? Ask him to come.
Yes, Lordship.
2-3 matters as soon as he comes.
Yes.
Because Mr. Padna has made a special mention, that's why I'm taking it.
Yes, sir.
Please ask him. And he should be ready with the file. I'm going to close it today.
Yes, sir.
All right.
Item number 9.
Mr. Padna, please wait for some time. Yes.
Item 9.
Yes, Mr. Mahati, what is this?
Lordship, the petition of the wife
You are the wife. Yes.
seeking the transfer of the petition filed by the opposite party husband from the Law and Civil Justice Senior Division Kaliko to Law and Civil Justice Senior Aska.
Only go to Aska, how far it is?
No, it's 80 kilometer distance in the entire area, Lordship. The petition will
80
be
kilometer, 80.
80.
Only go to Aska is 80 kilometers.
ନାଇଁ ସେଠୁ ହଉଛି 50 କେତେ ଭିତରକୁ ହରିଣା ପଦର ଭିତରକୁ ଅଛି ତାର ଗାଁଟା ସେ ଡାଇରେକ୍ଟ ବସ୍
ନୂଆ କଥା କହିବି ମହାନ୍ତି ମୁଁ Why do you want it to be transferred?
one small child with the mother, the petitioner. There is no other female member.
Where you said that your house is closer to Aska?
Lordship, in paragraph 6, Lordship.
Yes. Place it.
That the distance in between the parental house of the petitioner and the court of the Law and Civil Justice in Kaliko is more than 8 kilometers. In these circumstances, such as financial stringency, her ill health and her mother's ill health, it is not possible on the part to attend the Law and Civil Justice in Kaliko Ganjam regularly, which is a great hardship.
All right,
on her
take
part.
notice. Take notice.
Especially
Issue notice to the opposite party by speed post, fixing a short returnable date, requisites be filed by tomorrow. Tomorrow, by day after tomorrow, place this matter on
7th May.
Eh?
7th May.
7th May. All right.
stay up for the process.
Further proceedings in MAT case number 17 of 2023, pending in the Court of Learned Civil Judge Senior Division Khali Court, shall remain stayed till the next date.
Item number 10.
Yesterday matter they already had. This matter.
Yesterday it was passed over again. It was called out twice. You were not there. I had passed it over. If you remember correctly, I had passed it over. I had asked you some questions.
This is a matter, my lord, wherein
Is it not the same matter?
this is the matter, my lord, wherein he was granted a liberty to think about this particular case so far the prayer is concerned.
Yes.
Where the another person, my lord, he got selected. And
Oh, yes. He was not so he is not challenging the selection.
Selection.
So
For that,
if you don't challenge the selection, once he is appointed and he commits some misconduct, it is for the employer to look to look at it. How are you concerned?
for that instance, I have made a representation before the open to collector.
No, who are you? You cannot. that representation is not maintainable.
At the same time, he is working as a regular student and also a proxy man is working in that case.
I will simply, Mr. Patnaik, I will not entertain this application. But I will make an observation that it is open to the collector to look into. All right.
Yes.
Only representation.
Not representation. No representation.
Yes.
You are completely busybody, you are an outsider. You have not been
I
selected.
am also.
You are not challenging the selection.
That's
And once she has been appointed and she commits any misconduct, it is for the collector or the whoever is the disciplinary authority to look into it. You are not to bring it to their notice. The
Only
petitioner.
only after the selection, instantly he's pursuing.
All right, but you cannot be allowed to challenge
So,
because unless you,
very much-
so that is why I am asking you, why didn't you challenge the selection then?
But I am the challenge selection, but after selection, dual thing has occurred. And
So-
village
so-
also so much suffer.
So you are representing the public, general public or what?
I am also the locality of that.
So can you do that?
Yeah.
Can you do that?
No, nothing. Only I have.
No, Mr. Kindly consider it. If you must go through the lot of which I ignore.
That's
Who can be a person aggrieved in order to maintain an application and maintain a writ application? You must be affected. How can you be affected? Is the general public? Anyway, the petitioner has approached this court seeking the following relief. The case of the brief facts of the case are that pursuant to an advertisement issued on 21/12/2022 by the BDO Chilika for engagement of Jogan Sahayaks, the petitioner was one of the applicants. In the selection process, however, one Saraswati Maharana, bracket opposite party number 6, was selected and appointed as Jogan Sahayak. The petitioner's grievance is that the private opposite parties that said Saraswati Maharana has been, despite being appointed as Jogan Sahayak, has been simultaneously continuing her key course,
city course.
her city course, which is not permissible in the eye of law. So,
As a regular student.
and that too as a regular student. Stop. In this regard, he has submitted a representation to the collector to take necessary action against said Saraswati Maharana. This court finds that the selection of Saraswati Maharana as Jogana Sahayaka as such has not been challenged, has not been questioned by the petitioner. Certain acts of misconduct are alleged to have been committed by said Saraswati Maharana after her engagement as Jogan Sahayaka. So obviously, the petitioner, being an outsider, cannot have any grievance. So it is for the it is for the appropriate authority / disciplinary authority to look into the matter. In such view of the matter, this court is not inclined to entertain the writ application, which is disposed of by observing that it is for the key collector.
OP number 2.
It is for the OP number 2 is the collector. It is for the collector to take note of. No, it is for the collector to consider the matter at his own end and to take appropriate action as he deems fit and proper. Yes. Yes.
Oblivious.
Item 11.
And in this case, this is a content proceeding matter, wherein the direction was that to consider the representation in terms of the decision of the organization on the I got the information over telephone, my lord, that it is under active consideration. But what happened, my lord? Initially, those persons in whose favor, my lord, the SLP was there, order was there, they have already been granted with the benefit. Now, the cases where there is a direction for consideration of the cases in terms of the the decision matter already taken. Now a group of persons, about 90 persons matter, their cases have been listed and the petition's case is also one of.
Yeah, I have also disposed of several such matters.
About 90 cases.
You have to give time to
So
you are the petitioner.
my lord, they
Petitioner.
require 1 month time. my
Yes,
lord.
yes.
It is under active consideration.
Third learned counsel for the petitioner and learned AGA. Stop. It is submitted by learned AGA on instructions that the representation of the petitioner is under active consideration and that further time is required for its disposal. Stop. Release this matter after 1 month. 14th May.
Yes.
आज हेला नहीं 16th हेला ता पर करनो 14th May पर करनो 17th May.
Yes.
Learned State Council shall inform the status regarding disposal of the representation. Yes.
May I humbly submit, my lord, in respect of that is a batch of 619 there are applicants in that.
Yes, yes.
They are the out of the 619 in that batch, my lord, they have already been issued for document verification near about 512.
No, the application which was disposed of in your favor was for with a direction to the secretary to consider your case in terms of Dhananjay Day. So your grievance is now that that representation is still pending, it has not been considered. That is the limited thing that the court will see. Now they want only 4 weeks time to consider your representation. Either way, if they allow it, well and good. If they don't allow it, you can seek appropriate remedy against it. Correct. So it will come after 1 month. We will see. Yes.
Item 12.
Item 12.
Item number 13.
Item 13.
Lordship, kindly see order dated 19/3/2024.
19/3.
19/3/2024 your lordship. It often is to justify
shall take instructions as regards the justifiability of recovering interest on the amount paid by the management to the petitioner towards the salary component. Yes. What is your reply?
As per my oral instruction, my lord, the authority totally denied that they have not recovered interest, my lord. Only
A document?
lordship.
There is a document?
we have in our counter, my lord, can we have a glance to para 6?
Counter means counter of the opposite party number 3 which you have adopted.
Yes,
All right, para 6.
Para 6, my lord.
No, before that, where is that impugned order?
Impugned order your lordship at Annexure 1, page 9 your lordship.
You have to be paid interest on your dues excluding your liability. You have to,
And
you have to refund a sum of rupees 57,136 to the college as both principal and interest.
including the interest. And they have also given a calculation sheet. Your
Yes.
lordship kindly see.
Where is that calculation?
Page 10.
Acha, ठीक है. Then we'll come to the counter. To para?
Para 6, my lord.
Para 6.
Well, 3 amount is not disputed. The petitioner has received 2,12,000.
Yes, you want me to see paragraph 6, then place it.
Yes, ma'am. That the deployment respectfully submits that as per resolution of the governing body dated 19/3/2000 under Annexure A/3, a sum of rupees 1,39,000 has been deducted from the salary of the petitioner on monthly installment basis. The GPF amount of rupees 1,65,000.
This deduction is 1,39,000 deduction on towards what?
Well, I am coming to that one. Having deducted from the salary of the petitioner on a monthly installment basis, the GPF amount of rupees 1,65,454 was credited to the GPF account of the petitioner on 5/7/2000. The petitioner got granted as arrear amounting to rupees 2,12,233. This is admitted fact matter. And as the petitioner had already received a sum of rupees 1,97,662 towards his salary from the management of the college, and as such, petitioner had to get a sum of rupees 14,471.
That is 2,12,433 minus 1 lakh such and such. But subsequently, as per clarification received from the appeal number 2 that is director matter, the management of the college had deposited this amount as clarified by the matter OP2. We again deposited that GPF amount to the account of the petitioner matter. Towards GPF amount in the GPF account of the petitioner. Therefore, a sum of rupees 1,50,973 matter. After deduction from the amount matter, 1,65,444 minus 14,471 was due to the management. 1,50,973 matter. And this amount has been deducted on monthly installment at the rate 1,000 per month. Matter. So, matter, we have not deducted any interest towards the on GPF amount. Matter. I mean, interest total name. 1,000 lakha per month, we have deducted the salary component.
Then how did you arrive at this figure? The 1,65,000?
How do I clarify that matter? 2,12,233 is the total GIA granting amount. And if we deduct 1,65,444 towards GPF, then the figure comes to balance figure 46,700.
12,233 is granting it.
Yes,
See, through total 1,65,000 GPF is pura GPF is that's all right?
Yes, sir.
So remaining is
46,789 matter.
46,000.
এই କ୍ୟାଲକୁଲେସନରେ ସେମାନେ ଟିକେ ଅଦରାଇଜ କରିଛନ୍ତି ସେମ୍ ଆସୁଛି ମୁଁ ଏଇଠି କରିଛି ରଫ୍ ଫିଗରଟା 46,789 rest amount and
Rest amount means rest amount towards granting it.
yes madam
Yes.
yes madam
Out of which he has already received 1,97,000.
97 if from 1,97,642 if we deduct 46,789 it comes to 1 lakh.
While he was paid salary amounting to 1,97,762. No GPF amount had been deducted.
No.
Say amount was deducted.
No. Therefore, 1,65,000
been deducted.
Yes. Okay. If we deduct 46,000 rest amount of granting it from the 1,97,762, then it comes to also 1,50,973. And this amount has been deducted on monthly installment basis at the rate 1,000 per month. And as such, the total recovered amount, my lord, 1,39,000 has been recovered from the towards the salary component.
Salary component is 1,65,000. Sorry, GPF is 1,65,444 over 2,12,233.
Yes.
Granted amount of 2,12,000. How could GPF 1,65,000? Minus jeting paisi the account.
সেটা রেস্ট রইলা 86,799 আমি ଦେଇଛୁ ତାଙ୍କୁ 1,97,762 ଯଦି ସେଇ 66,000 ଟା କଟି ଦିଆଯାଏ ରହିଲା 1,50,973 ଆମେ ଏଇ ଆମାଉଣ୍ଟକୁ ଡିଡକ୍ସନ କରିଛୁ ଯୋଉଟା କି ମ୍ୟାନେଜମେଣ୍ଟ ଦେଇଥିଲା ସାଲାରୀ ବେସିସ୍
So what you say?
ଆଉ ତାର ଇଣ୍ଟରେଷ୍ଟ ଆମେ ନେଉନୁ
No, your lordship. Kindly see Annexure 1, your lordship.
I've seen Annexure 1 is very confusing.
Your lordship.
ହଁ କନଫ୍ୟୁଜନ
They are saying that
There is on the right side there is a column for interest.
Your lordship.
Yes. It has said that the interest ଅଛି.
So far as
କ୍ଲିୟରଲି ମାର
ତାଙ୍କରି କାଉଣ୍ଟରରେ
ଫିଗର
Annexure A/3 ରେ କହିଲେ 1,500 ଟଙ୍କା per
You file a further counter, Mr. Agru. File a further counter including a chart, comparative chart, clearly showing what is the amount you are recovering. And if you are not taking any interest, then how do you explain Annexure 1? Annexure 1, the second page of Annexure 1.
There is interest on your dues, your lordship.
Let's see the GPF interest rates. Then
further affidavit matter
is it not confusing?
I will file further affidavit.
Further arguments. In course of hearing, Sri V.S. Raiguru and Council appeal for the managing committee.
Both matter 3 and 4.
For the opposite party numbers 3 and 4 emphatically asserts that the college has not recovered any any amount towards interest from the petitioner. So this court found that the document enclosed as Annexure 1 shows a table indicating the amount recovered towards interest for different periods. In order to reconcile this incongruity, let a further affidavit be filed by opposite party number 3 and 4, clearly indicating through a table as to the amounts due to the petitioner and to the college, along with the amount required to be deducted from his salary in future. Yes. Is this matter on? 30th April. Mr. Raibru, 30th April.
Yes.
Prepare a chart.
Lordship, interim order to continue.
Interim order to continue.
Obliged words.
Item 14
and plus.
That's all.
item number 15.
That's all.
Item number 16.
May I please, Your Lordship, I am appearing on behalf of Mr. S.B. Jana. Your Lordship, on the last occasion, Your Lordship has directed to take instruction regarding the representation.
The order date is concluded with video criminal. Last order was that order dated 19/3/2024. What is 19/3? The petitioner
Matter relating to grant of family pension.
What action was taken on the representation submitted by the petitioner to the video on 25/5/2021?
Yes.
So last chance was granted.
My lord, we have received an instruction on 30th March 2024.
Yes.
Wherein we have stated, my lord, that she is not entitled.
No. What happened to that representation? Was it disposed of? No, even after 30th March, the matter was taken up on 9th April. This is the order. Mr. A.R. Das, Learned Additional Government Advocate, informed that the order dated 19/3/2024 was communicated to the BDO Kirmira block by letter dated 23/3/2024, soliciting the required information. No information has been received as yet. He requests for one more chance. This is the order. Has this order not been communicated? You were to inform the court what happened to the earlier representation pending before the BDO. And you had informed the BDO by letter dated 23/3/2024.
Stated the status of the video. My lord, previously, my lord, it was DIO of school and the BDO, my lord. Thereafter, my lord, after the reorganization of the cadre. Now it is coming under the BEO. That is what it has been clarified.
That's all right. But at the relevant time, it was BDO in 2001.
Yes.
So that is why this court wanted to know what happened to that representation. So this was communicated. Mr. Das told me last time, I have mentioned it in the order, that it was communicated to the BDO Kirmira by letter dated 23/3/2024. Now what has happened?
BEO, he has given.
When did he submit? That was in 30th March.
On 30th.
So this order was passed after 30th March, on 9th of April. No, Mr. You are, the court is being paralyzed now.
Well, actually, this was actually.
Whatever may have been there, there is an order. There is an order here.
May I pray?
Yes.
This information, even though it is the letter dated 30th March, but actually this was not placed before a lordship.
Yes.
This was actually received by our petition 9th of April.
Then what was informed to him by letter dated 23/3/2024? Find out. Your letter dated 23/3/2024 to the BDO.
BDO, my lord, from BDO, my lord, there is no information.
No, not from BDO, from you, from your office.
It has been informed.
So on 23/3/2024, please look at that letter, sir.
This may come on Friday, man.
As requested by London State Council, is this matter on 19th?
Item 17.
May I please? Item 17, Lordship, pursuant to your Lordship's last order. And last night I was served with the copy of the writ petition without the annexation, Lordship.
My lord, this is a covered matter by a lordship, my lord. Where I have challenged the order of the director, my lord, where he has no jurisdiction. As per 2000 circular, my lord, the regional director has to hear all the appeals.
My lord, lordship, there is that order dated.
No. Before that, I had passed an order.
Yes.
No, he had requested on my lord that he will be reconstituting the file and you were required to give him a copy of the writ application. You have given him without the annexes. I don't know, our clerk has given, sorry, my lord.
Lordship, I have
Your clerk is controlling you. That is what I will record. I will say that. No, sorry. The council submits that his clerk has done the mistake and he is bound by the mighty clerk. Sorry, my lord, I accept the mistake. What are you saying? Sorry, my lord. Give a copy, sir. Sir, today only I will. Yes, this is matter on, I will call it on 18th.
Before that,
Your Lordship,
I just want to bring that to lordship.
No, I will. Sir, order to at least comply, no? The judicial order has to be complied.
Yes.
Then we will go to the.
No, there is another judicial order which.
What is that?
My lord, I was directed to take the instruction with regard to the latest position of the management.
Yes, on that day after tomorrow.
Yes.
As requested by.
I have collected that. That is why.
As requested, yes, this matter day after tomorrow. Lordship, can you take on Friday, my lord? Or later on 19th. Obvious, my lord. Item 18. Serve a copy immediately. So.
Lordship, item 18. Lordship, I may permit it to implead one Pragya Rani Panda, who is working against the post which is being claimed by the petitioner, Your Lordship. Otherwise, this petition will not be maintainable since that person is a necessary party.
Where is you filed an IA?
I will file, Your Lordship.
Lord, this is a matter of 2013. Order director was in my favor. Since 2020, I was not getting my post was not approved. I am not getting my salary. Only point is decided. A person, elected person, Panchayat, he was elected as nominee of Panchayat Samiti. And by suppressing all the facts, he could able to got an appointment from the governing body. Then when the matter came to the knowledge of the governing body, by following principle of natural justice, he has terminated. Now that has been confirmed by the director. Only this is the issue.
No, but if he wants to file an application seeking to impede somebody, can we stop him? We may not allow it. That's a different matter. My husband is stopping him from filing that petition. He wants to file it.
Holland has not filed the petition.
I'll call it on Friday. Any petition
Next week because some difficulty petitioner would not be. I have to also file the affidavit to the effect.
So what?
He has to put the signature as well.
So what? He'll come. It is in his interest. If he wants to impede somebody, according to him is a necessary party, then it is in his interest that he should come with due promptitude and swear the affidavit.
Lordship, my only request matter is proceed to next week, Your Lordship, instead of Friday.
You are Mr. Shekhar,
my lord.
Shri Shekhar, learned counsel appearing for the petitioner, submits that he has instructions to file an application with right to impede a necessary party who has been wrongly left out. Stop. He requests for some time. List this matter on 23rd April. IA, if any, be filed in the meantime. Stop. This being a case of the year 2012, the parties are requested to come ready for final disposal. Stop. It is made clear that no further liberty shall be granted. Yes.
Much obliged, Lordship.
19.
My lord, the petitioner applied for the post of junior Hindi translator. Your lords can come to Annexure 1 at page 14.
Annexure 1.
Yes, my lord.
Junior Hindi translator. National Institute of Science Education and Research.
This is a postcode number 3. Postcode number 3, the essential qualification. Minimum, all these things, age, not more than 32 years as on 30th of April, 2011. Page 15.
Yes.
I applied for the post. I was having all the eligibility. Therefore, you also can have a look to the call letter that was given to me at page Annexure 3 at page 26.
Yes, sir.
Call for written test by for the post of junior Hindi translator at Niger, Bhubaneswar. Date 10/9/2021. Then venue, etc. Reporting time 9 AM. I reported according to the notice issued to me. I was intimated that the interview is cancelled. And I requested them in my application dated 18th of October 2021. My lord, let me place it.
Yes.
As per advertisement, this dated issued to by your institute. An interview was organized on 10th of September 2011 for the post of junior Hindi translator, but out of 5 candidates called for interview, I was the one and only candidate who appeared on the interview. As a result of which the institution cancelled the interview, and having all essential qualification and working experience, I could not sit in the exam. Further, when the exam will be organized and my candidature for the same will be considered, is not informed to me, and nor any such information regarding this is published in your website. So you are kindly requested to provide me necessary information. Sir, do not treat this application as a demand for the employment, etc. I intimated because that was cancelled. You also kindly have a look to at page 28. Of course,
28.
Hindi, essential and desirable concern, including the work inspection. Ultimately, the
Yes, same letter. The same.
This is, I'm sorry, that was in translation. Your Lordship, and Annexure 5, cancellation of recruitment for the post of junior Hindi teacher at page 29. This was intimated to me, the Triparthy, etc., that with reference to your letter received through mail regarding the cancellation of a recruitment for the post of junior Hindi teacher, I'd like to inform you that the institute will advertise the position against in near future, and your candidature for the same will be considered. You will be informed accordingly whenever the recruitment process will be initiated. In case of any change on your contact address, you please inform us. That is what the response to my reply. Then your Lordship, kindly have a look to Annexure 6. An advertisement was issued on 30th of March 2012 in place of junior Hindi translator. They now advertise it as assistant Hindi at clause 4, my lord. That the qualification, etc., my lords, can have a look to page 32, post number 4, assistant Hindi. All these things are essential that I do have. Only my lord can have a page 33, age not more than 28 years as on 30th March 2012.
Which was 32 in your.
That was 32. I was eligible and I was called. I was intimated that whenever the post will be there, I will be given a chance. Now they changed the post and they reduced the age, as a result of which they did not select. I was not eligible to appear in the test. Then your Lordship can have a look to. I filed the writ application. This Honorable Court, appreciating the difficulty, dated 10/5/2012, the process of the process of selection for the post of assistant Hindi pursuant to the advertisement.
No appointment shall be made. Yes. Okay. So that interim order still continues.
Yes, possible. Now, my lord, a counter was filed. Your Lordship can have a look to the counter filed by Niger. That was on 26th of September 2012. They narrated everything, but one thing they said, that paragraph 7, page 4 of that.
Yes.
That in response to paragraph 5 of the petition, it is humbly submitted that it is a fact that the petitioner was shortlisted for appearing in the written test interview that was scheduled to be held at Niger on 10/9/2011. The written test interview was cancelled due to non-availability of sufficient number of candidates. Then your lordship can come to paragraph 8. That in response to paragraph 6 of the writ petition, it is humbly submitted that it is a fact that no communication with regard to reconduction of written test interview was made to the applicant, since no new date regarding conduction of a written test interview had been decided by the institution. Then your lordship will kindly say paragraph 9 that in reply to paragraph 7 of the writ application, it is humbly submitted that it is a fact that the post of junior Hindi teacher against which the petitioner was a candidate, the test interview in respect of which had been cancelled, has been redesignated as assistant Hindi, since as per the provisions under the rules and etc. Now, my lord, they said that is redesignated. Redesignated and the post, my lord, they go with same. And that cannot be an independent post, creating any age of recruitment, etc. Qualification, everything, scale of pay, everything is there. Now, if it is redesignated, they cannot change it to a new status or new spirit. Now, my lords, after that, I gave a rejoinder. In the rejoinder, my lords, I refuted the stand taken by the counter. On the list, my lord, the last one, that is on 17th of January 2024, an additional counter is filed by the Niger. They say they heavily rely on Annexure A by 2. As per running page 5. May I place it, my lords? As Hindi will be little, that's my lord will be able to understand that. राष्ट्रीय विज्ञान शिक्षा एवं अनुसंधान संस्था भुवनेश्वर कृपया अपने दिनांक 10/8/2021. Minus may note this. The selection was 11 sometime in 2011. Till now, my lord, they said no interview, nothing else. Now, 10/8/2021, a correspondence is made from Niger Bhubaneswar to their head office at Bhubaneswar at Delhi. कि प्रत्यंत सुरक्षा नंबर देश का संदर्भ ले जिसके माध्यम में नाइजर भुवनेश्वर के कनिष्ठ हिंदी अनुवादक लेवल 6 के एक पद के सृजन का प्रस्ताव विभाग से अनुमोदन भेजा गया है. That means still 2020-21, sir, the post has not been redesignated or there has not been changed. If that continues with that, then the question of not considering my case and ignoring my from 2011, some plea or other that we have redesignated, the post is not yet advertised, and what they say, my lord, in the additional counter, can I look to one paragraph? They want to escape this by stating inter alia. Paragraph 4. That it is humbly submitted that as per the minutes of the meeting of the selection committee, paragraph 3 is, I'll press it from paragraph 3, is a short counter, there is no difficulty. My lords, I will start from paragraph 2, that the Niger has already filed an affidavit in the aforesaid case. During the pendency of the writ application, Government of India has created a new post of junior Hindi translator level 6 in Niger, and the same was communicated on 14/1/2022. So that may be underlined. So this new post of that is they say assistant junior, that is they call it
Junior Hindi translator.
was created on 14th January 2022. Till then it was not there. In view of this, the fact stated in paragraph 9 of the counter with regard to the redesignation of junior Hindi teacher as assistant Hindi no longer survive. My lord, who has given that affidavit? They gave the affidavit that we redesignated it. And we are having the same thing of the some age. Now in 22, they say, since the central government has approved in 2022, that is why the question of junior Hindi translation no longer survive. I am not coming to 22, I am coming up to 2011, sir. Then, moreover, the fact that the post of junior Hindi teacher has been redesignated as assistant Hindi teacher also not correct. Their own statement, now they counter it, my sir. They give an affidavit. The deponent wants to bring the fact to the knowledge of the Honorable Court by way of filing the present additional affidavit, copy of Annexure A/2. I have read it, sir. That it is pertinent to mention here that so far as the advertisement dated 31/3/2012 on Annexure 06 is concerned, the same has been given effect to, except the post of respect of serial number 4, and nobody has been appointed against the said post of assistant. They could not have been, because that is an interim order by the Honorable Court. That it is humbly submitted that as per the minutes of the meeting of the selection committee for the post of junior Hindi teachers, which was annexed to the counter affidavit, the applicant of the application of the petitioner will be considered at par with other applicants for the post of junior Hindi translator, and then when the advertisement to that effect will be published by giving him age relaxation. My lord, in the meantime, 12 years have passed, and they do not show that when they are going to have it. They just showing me some jackfruit and telling that when it will ripe, you will eat it. Thereafter, my lord, they come, it is further submitted that such as relaxation cannot be cited as a precedent for others in order to claim age relaxation. I think they are sitting as a court. This benefit can only, my lord, extend that this order cannot be taken as a precedent. They create it, they break it, they say that we have done it earlier in a wrong manner. Now they say that whenever you will put that advertisement, you will be given benefit, relaxation, etc. Whatever this 15 years in between, sir. And I have been waiting for that whenever it will come and I'll have it. This is the annexure, my lord. This is the explanation they have given. My humble submission is, since they created in the year 2022 by redesignating it, now they say you have not redesignated. That post is continuing. Now you are changing in 2022 and show me that whenever we will advertise, your case will be considered. This should be taken in that manner, my lord.
Who is appearing? Yes, we'll take it up next week. We'll keep it part hard. We'll continue next week. Part and part. Let's just matter next week.
Right. Item 20.
Yes, Mr. Panda, has your person come?
Yes.
Yes, State Council. Has your come? Please inform.
Yes.
Please inform. I think he was there. I saw him.
He is coming.
Weekly registered Akide. Item 56. Because once I take up another matter again, it will.
Yes.
So, yes, are you ready with the affidavit?
I beg your pardon, my signal couldn't be appear here.
It's all right. Are you ready with the affidavit?
Yes.
Very good. Very good. Very good. Doesn't matter. So, what is your stand? When is that affidavit? The last affidavit again, this is by Purna Chandra Ratha. You are, Mr. Panda, you are referring to an earlier affidavit.
I have got a copy of an affidavit showing affirmed by
Mr. Ratha, yes.
When was it filed? When was that affidavit filed, please?
It is dated Manchester.
On 12th for 12th April, you know,
12 for 5 days. 5 days.
Manchester affidavit being affirmed and
No. I have an affidavit of submission which was sworn on 16/1/2024. There is no other.
that is an earlier affidavit.
earlier, your lordship.
Deed affidavit was here, nine. Say affidavit out copy the. Anyway, what have they stated in that affidavit?
So far as the first affidavit that your lordship is holding is concerned, according to the affidavit sworn by Mr. Roth on 2/2/2024, he has stated at paragraph 2.
No, but who is this Purna Chandra Ratha?
He is the husband of the informant.
So what does he say?
He says at para 2, second page, that the alleged amount is 2 crores 82 lakhs 51,000 and not a single pie has been refunded till date. This he is saying on Dui 24, identified by the same learned counsel. Now the informant in her affidavit, which she has filed, she had filed an affidavit on 15/12/2022. There also she had said the same thing. That the amount in question is 2 crore 82 lakhs 51,000. And she says that the details she has given at Annexure A. And she says at paragraph 3 that not a single pie has been paid till today. 2 crore. Now in her affidavit dated 5/4.
You have an extra copy of that affidavit?
Yes, Lord. It's a Xerox copy.
Again, let me just find out. And you find out if you have filed that affidavit, why is it not on record?
Yes, Lord.
अच्छी नहीं नहीं सिर्फ तो भाई बनती है मत दिए थोड़ा जोटा सिर्फ पूर्ण
In this latest affidavit, what she says is
refunded is
that 2 lakhs, 2 crores 82 lakhs 50,000 is the amount received and not a single pie has been refunded. Then she says at paragraph 3 that 32 lakhs 72,700 has been received apart from this amount from her husband, Mr. Roth.
But that is not mentioned in the FIR.
No.
This is an additional.
Out of that, she says 20 lakhs 93,400 has been refunded. And
so this is basically, as I find, you have utilized the machinery of law for recovery of your personal.
Yes.
You want to arm twist the petitioner through a criminal proceeding to get back your dues. Approach the civil court if she has taken and not given you the money.
But there is a.
Have you gone through any case laws in this regard? The court will not be a party to your personal recovery efforts.
But there is a huge amount of 2 crores
Yes.
and
that I will be asking on the last occasion also. I had asked Mr. Pandya, even though it is a private dispute, just for the sake of maintaining balance, what amount is your client ready to pay?
We have filed an affidavit below enclosing a statement of accounts. The total amount which I have calculated from that statement of accounts is, it comes to around 90 lakhs in cash transfer, in bank transfers. Beyond that, cash transfers have also been.
20 lakhs is by cash.
No, 90 lakhs.
Cash is by 20 lakhs. That is what the IO has said. The IO has given a detailed the chart showing the transmission of amounts on different dates.
Right.
To which bank? Canara Bank, Bandhan Bank, Bank of India.
Next year, it shows that bank transfers of about 90 lakhs have been.
90 lakhs.
Right. So 1 crore and 10 lakhs has already been paid.
Where is that proof that 1 crore has been paid?
My lords, if the IO says 20 lakhs in cash, then your lordship may not have to do that is
instruction. No, you say 20, according to and actually received by Ravindra Thakur 2,50,000.
IO has filed an affidavit that 2 crores 82 lakhs 51,000 was transferred.
I would like to know what amount has been paid by the petitioner.
But last part, my lord, in the affidavit.
No amount has been yet been received by the complainant or husband from nothing.
That is the instruction was taken from the informant by the IO. On that basis, that he has supplied that instruction.
Then how the court
The IO, that the informant, whether he has
informant also says that she has not received any amount. So this court is from which they have refunded rupees 20 lakh 93,400 only till the date.
that apart from 2 crores 82 lakhs.
So 20 lakh, you admit to have received 20 lakh 93.
Yes, sir.
They admit it. Yeah, you are adding the amount supposedly taken by your husband to this now, which is enlarging the scope of the trial here.
Only from
As you had filed this FIR,
yes.
out of which 20 lakh has been received. So it comes to around 2,60,000 is the amount due. What amount can you pay? 2 crore. And this is not cannot be equated with an economic offence. These are between two individuals, private individuals. So the court will assume the role of a recovery agent. No. Last time, senior counsel Mr. Joswant Das was referring to that decision.
Yes. Contract between the parties.
A private contract between two parties. Somebody fails, so he should approach the civil court. That is the law. But why will the prosecution shoulder such a responsibility? Isn't it?
Yes, madam.
Look, my submission to your lordship's query is this. I have placed before your lordship the facts. Now I leave it to your lordship may decide. And whatever amount your lordship is deciding, your lordship may fix it by way of installments. So,
No, okay, you can suggest an amount. I 2,60,000 to call for 2 lakh for 2 crore for
no, say like
reasonable amount. You suggest some amount.
admittedly they have received. So for the balance amount, your lordship may decide and fix it by way of installments.
So you admit 1 crore?
10 lakhs. 1 crore and 10 lakhs has been.
Mr. Das, can you give us a short note? After he concludes the argument, give a short note.
You can.
All right.
A short note is there, my lord, filed on the 6th.
There are so many affidavits. So many, it is very difficult, very cumbersome to go through. Give a short note. Whatever Mr. Panda has said now, I'll consider it. I'll pass it. All right. It will be in the interest of both parties. But you keep it in mind.
Yes, sir.
The court cannot be the recovery agent.
No.
Particularly in a private dispute.
Yes, sir.
You are a young counsel. Have you not gone through any decisions in this regard?
No, your lordship, I beg.
You should. This is not economic.
Yes, your lordship, I know more than 20.
There is a difference between an offence which can be designated as an economic offence.
Yes, your lordship.
This is a private dispute.
Yes, your lordship.
Somebody takes money and doesn't pay. Okay, Mr. Panda. Let Mr. Das submit a short note, very short note, 1 page.
Madam.
Not even 2 pages.
Madam.
Scanning. Oh, that affidavit has not been scanned. That is why I'm not getting it. Anyway, if it is on record,
We can.
All right.
Madam, disposal.
I will pass orders. Hearing concluded, order reserved.
I don't know, 20.
Supplementary list will go. No, anything. Yes. Yes.
I'm challenging Annex to 1. Annex to 1, by virtue of which I was, my lord, getting train matrix scale of pay from 1981. But by virtue of this letter, that has been reduced to train matrix scale of pay.
You have disallowed the trained matrix scale of pay to the teachers having IA qualification who are allowed the said scale from the date of acquiring IA qualification. Yes. What is wrong in it?
My lord, they have reduced the by virtue of this letter, the benefit which was given to me has been taken away.
No, you are, let us see your.
My lord, I was appointed in 1970.
1970?
70 as an assistant teacher. At that point of time, it was on trained post. So I was appointed there. At that point of time also, I don't have any training qualification. My lord, the post became trained in 1974. I obtained IA qualification in 1978 and 80 BA. After getting the higher qualification, by virtue of their own resolution, I was granted trained matrix scale of pay. And I used to get it till this letter.
So what?
31/1/2011, I retired. And this letter I received, my lord, just before that, and thereafter I filed this petition. Only thing, my lord, whether he is alive or dead, that information I don't have. Because it was filed in 2012. And
you find out, otherwise, why will we waste time in it. Next week could actually,
ସେଇଟା ମୁଁ କେବଳ verify କରିବି.
no, let's this matter next week as
We were
land
50
council.
years at that point of time.
Land council to the petitioner wants to take instructions from her client. Next week, next Tuesday, we'll come on next Tuesday. Item 21.
So let's.
May I please? This is.
Yes, please.
Yes, my lord, this is a small case. Writ petition involves a claim for payment of arrears of salaries. The facts are not much in dispute. The only issue that requires examination is the maintainability, because admittedly the writ petition is filed against a private college.
Who is the
My lord,
opposite party?
my lord,
Tiga Institute of Technical Education.
party number 1 and 2, they have filed a counter affidavit.
Gurukul Academy. Yes.
Opposite parties number 1 and 2, they filed counter affidavit, but since last many dates they are not appearing. My lord,
Now they are here, I think.
No, in this case, I am appealing for opposite party 3. We have no role to play because any amount.
Your Biju Patnaik Institute University.
Any amount has to be paid by either of.
Even if they do not appear, the court can always raise that.
The last occasion,
Even if
was issued.
for my counter, the counsel who is appearing, Mr. Sinha, who is appearing for 1 and 2, he refused to receive counter for.
Either 1 and 2 are two private institutions. If they do not appear, they do not appear. If notice is sufficient, notice has been sufficient.
Yes, notice was reissued, and let's will find OP number 2 actually is the trust that runs the college.
But they have filed a counter.
Yes, my lord. They have filed a counter way back in 2000.
Yes, sir, of admission notice returned unserved from OP2 with a report that OP2, the Gurukul Academy has shifted from the said address. Anyway, you satisfy the court. How is this maintainable?
Lord, the
No.
claim is for a period from January 2011.
Notice against OP number 3 is sufficient.
Yes.
OP number 2 has already
Filed a counter.
Yes.
Yes, my lord. Lord, the facts are not much in dispute. The petitioner worked with the opposite party number 1 for a period of from January 2011 to November 2011. The claim for arrear salaries is 88,000 is what the petitioner claims. The opposite party number 2 in their counter, they admit, lords may have the counter, para 8 and 9. My lord said, paragraph 8 of the counter affidavit of opposite party number 2. So, may I place it, please? That it may not be. So, basically, they say that because of paucity of finances, they were unable to pay. And at para 9, there is a dispute with regard to the number of months for which the payment is due. The petitioner.
Why are you getting into all this?
I am not getting into. I say forgo that part. So, this is the.
You satisfy the court
Facts. As far as maintainability is concerned, Lord, in the writ petition, pleading has been taken at paragraph 2 and at paragraph 11. There are two aspects, my lord. The twin test, when a writ petition is filed against a private body, twin test, one is discharging of public function and public law element has to be satisfied. So there are pleadings here in paragraph 2 and paragraph 11. The first point is the discharging public function, which is not in dispute. The second point is public law element. Now for public law element, Millards, I rely upon the first statutes of the BPUT. But since the law on this issue has taken twists and turns over the last 10 years, my lords will see part 6 of the statutes.
What is your submission first?
My submission is that, my submission is this, my lord, in short, that the first statutes which provide for the condition of affiliation impliedly impose a duty on the opposite party number one as far as payment of salaries to the teachers or supporting staff are concerned. Here, the petitioner is not a teacher, he is a supporting staff. So I say a positive obligation is created under the statutes, which is a subordinate legislation having been framed under 31(1) of the BPOT Act. So, my lords, what I say
that according to you amounts to public law element. That is the involvement of public law element here.
My lord, there are two things.
Nothing. This is purely enforcing.
My lords,
wait. You are trying to enforce a contract of personal service. That's all.
My lords,
this is rarely covered by the recent judgment of the Supreme Court, St. Mary's case. Nothing.
My lords, I will come to that. My lord's judgment is there also, and the Honorable Supreme Court judgment are there. But there is a distinguishing factor, my lords.
Please.
Yes. My lords will have a look at
statutes.
St. Mary's. My lord,
you come to the facts of your case, then we'll go to
yes, my lord, facts of my case.
Your claim is for arrears salary.
Period. Yes, my lord. Please.
So, how does it involve any public law element? Tell me.
My lords have always distinguished between payment of arrears and between enforcement of personal contract, which inter alia has included suspensions, terminations, disciplinary proceedings, or enforcement of any other condition of the contract of employment. But my lord, as far as arrears of salaries are concerned, not particularly against the state. So, my lord, a general obligation is created to discharge that duty, and it is not restricted to the state alone. So, here my submission is arrear of salary, therefore, my lord, starting from the Anandi Mukta Sadguru, 1989, that is a judgment where the
Yes.
Yes. Para 20. Basically, before I reach para 20, what I seek to submit, my lords, is this. That is my lord's judgment.
Yes.
What I seek to submit here is that this is one of the few cases on this subject of exercise of writ jurisdiction against a private body, where the claim is for payment of arrears of salary. All other cases, my lords, where there are cases where writ petition has been entertained, and there are cases where writ petition has not been entertained, the latest being St. Mary's versus Rajendra Bhargav and my lord's judgment in Dr. Pradeep Kumar Dhal. So, the distinguishing factor is, I reiterate that arrear of salaries fall under a different category, and enforcement of other aspects of the relation between the employer and employee fall under a separate category. The courts invariably have declined to exercise jurisdiction, the writ jurisdiction, wherever it involves a challenge to termination, suspension, or any other disciplinary action. My lord, the twin test that I adverted to, and my lords will see para 20 of this 1989 to SCC. The term authority, if I may place it, used in Article 226 in the context must receive a liberal meaning, unlike the term in Article 12. Article 12 is relevant only, my lords, if I may skip those paragraphs and come, those sentences and come to the crux. My lords, somewhere in the middle, the sentence starts, they may cover any other person or body performing public duty. The form of the body concerned is not very much relevant. What is relevant is the nature of the duty imposed on the body. The duty must be judged in the light of positive obligation owed by the person
or authority to the affected party. Now, my lord, here I refer to the statutes. If my lords may have a look. So, my lord, if I am unable to satisfy that this duty is there under the law, otherwise I would not have a case in a public law forum. Let's we'll see part 6, affiliation of colleges. This is a subordinate legislation under section 31 of the BPOT Act.
Page?
My lord, at the bottom, my lords will find the page number 42. 41, 42. First, I will take my lords to the consequences of not. 41. At the bottom, my lord should see this. It starts clause 50. So, subclause 3. The university, the one, if an institution fails to fulfill any condition provided in these regulations or fails to comply with the directions of the university on the basis of the recommendation of the affiliation committee within a reasonable time, the university may pass such orders including suspension or partial total withdrawal of affiliation of the institution, college in respect of the courses affiliated to it. Then 2, the university shall have the power to suspend, withdraw affiliation of a course in an institution, college, and or affiliation of an institution, college, if satisfied that any of the conditions provided in the terms of affiliation as per regulation is not being observed. Number 3, the university reserves the right to cancel the affiliation of a college if a college, my lord, turns over to the next page. And my lord comes to Roman 8. Roman 8. Non-payment of salaries as per norm to the teachers and other supporting staff. My lord, what I beg to submit is that there are consequences for, of course, this is qualified as per UGC norm, AICTE.
You have already approached the university.
Yes, my lord. University was approached by a representation that is rejected. They did not respond.
So why in such a situation, why was the maintainability aspect raised?
My lord, maintainability aspect was initially raised at the time of admission. My lords, at that time, after reducing this 89.
But if you have already approached a statutory authority, which is the university in this case, by submitting a representation,
yes,
and they have to take a decision,
they have to direct.
Direction can be issued. Yes.
My lord, now that institute became an autonomous body, my lord, not within our control.
That is after
filing of this petition, man.
So in time filing of the while
Section arose,
I somehow came to notice this annexure 8. You should have placed it at the first instead of going to the maintainability. Maintainability becomes redundant here. Because annexure 8 admittedly and by registered post it has been addressed to the registrar. And probably either no action was taken or it was no action was taken.
In this case, my lord, I entered my appearance 3 months ago, my lord, not prior to that.
Maybe.
Notice are not issued sufficient bad subpoena against opposite party number 1. On being appeared, I filed my counter.
No, you are appearing for opposite party number 3.
3.
Yes. Notice was sufficient earlier.
My lord, may I please clarify? Initially,
Probably, since notice was not issued to the university at the initial stage, rightly, wrongly, for whatever reason, the Honorable Court decided not to. The lordships who were hearing the matter at that stage. This was in 2024.
By filing counter at para
You filed the writ application 16/4/2013.
13. In the November 2023, notice issued to opposite party number 3, my lord.
It was first placed before division bench, then it was, say it's a single judge matter, so notice was issued. That's all. Thereafter, it has not been heard really.
No, my lord, only in 23 September 15, in 2015 also they filed counter.
So you do one thing, you take instruction.
May I pray? My lord, may I kindly give a glance to para 3 of my counter, my lord. What can I do for this petition, my lord? I have already expressed in the counter.
Upon counter, where is your counter? There is no counter.
Yes, that is why
OP number 2 is there, but you have OP number 3, isn't it?
29 February, I think they counter.
What's your counter, dekhle?
Counter filed by OP number 3. There is a noting in the constitutional manner.
Flag A, okay. Flag A is an additional affidavit. The institution may have become autonomous presently, but at that point of time, it was affiliated to you. You had a full control over it.
Even if at that time, what was our capacity or what was our power, we have expressed at para 3. We have specified appointment and recruitment. It is purely the matter of opposition partner 1 and 2, my lord.
That can be considered by this court. That what was the role of the university vis-a-vis the statutes? That can be considered.
Duties created.
As you they have issued notification, they have selected the person, they have approved their appointment without any communication or intimation to us, my lord. So we have no control over regarding appointment of teaching and non-teaching staff of the said college. So far, conducting examination and educational part is concerned, we are the authority. We have control over that institute.
And you have to reply to this, whatever has been stated with reference to these first statutes. Because the university cannot simply wash its hands off. Where will the person go then? Where will the person go then? You have given affiliation on certain conditions.
May I pray, my lord? Your lordship may dispose of the petition. Directly opposite. Take a decision so that
I will pass an order. The university reserves the right to cancel the affiliation of a college if a college wants to, including non-payment of salaries as per AICTE norm. To the teachers and other supporting staff. He is a support staff now. Well, there is, the university has the power. Well, arbitrarily invoking that power, he has approached the university. So one action was taken. That is the only thing you have to tell me, then only I can pass that order.
May I pray, my lord? Arbitrarily, Annex 8 is available. That is a representation. And in the top, my lord affix the postally receipt.
কিছু নেই বর্তমান এটা করে দেবে কোন ইউনিভার্সিটি কই দেবে যে আগে সে অটোনমাস এগুলো আমি কিছু করতে পারিব না
আমার পাখে একজন আউটসে ক্ষমতা নাই কই দেবে আমি
2013 রু পেন্ডিং রাখিবু কোর্টে
আমার সাথে কি দেব
আপন কথা কোনি আই উইল ডিসপোজ ইট লাইক দিস আমার where will the person go I know what you will say sir now it was under our it was affiliated to us but now we have no control
there যদি নোটিস যাইতাম তো কোন হই পারে
বিচার সিরিজ বুঝিবে 2013 রে
আর বর্তমানে আমরা
নোটিস হেইনি তো সেটা বুঝিছ কই
In fact, till 22-23, it was an affiliated college. A memo was filed, my lord.
that you will consider. Now, all right. You just take instruction.
Yes, well, I have to. So difficult is that the opposite partner one is and to their in spite of notice they are not appearing.
My lord, off the record, it seems the councils have not been paid. That is why they do not. Off the record, I cannot.
The council has also a annual salary. That I cannot consider. So the petitioner I can consider, but you get the point.
Well, I have got the
So the university, if I dispose of now, the university simply
already disclosed our mind at para 3.
Your disclosure, go to it. I will see to it. Don't. Where will that person go? At this stage, at this stage, he will go to the civil court.
No, my lord, if the party,
you may say that for this reason, he is not, the claim is not admissible. That's a different matter.
We are not disputing, I am not against the petitioner, my lord. I am not saying that he may not get, or his petition may be dismissed at the threshold on the point of jurisdiction or maintainability, my lord. I am saying that the person has work, he has to get his deliberate and admissible dues, my lord. But the authority who has to pay in spite of my lord's notice is not appearing. How we daring to not appear before my lord's, my lord?
No, no, it's not a question of daring.
Yes, my lord, he is daring to appear.
No, no,
In
it's
spite
not
of
appear.
this.
Can appear. The court can issue a warrant. It's a court.
So this is the case for issuing a notice against
Notice has been issued, they have filed a counter. The counter is already on record.
They are not appearing.
Counter is on record. We go by their counter. Their pleadings are there on affidavit. So we can consider it even if they do not appear. Anyway, heard in part, please this matter next week. In the meantime, 30th April. 30th April.
May I pray, my lord?
In the meantime, I am just directing you to take in the meantime, Sri Rautray,
My lord.
Sri Rautray, Sri Nihar Ranjan Rautray, Nirmal Ranjan. Sorry, forgetting. Sri Nirmal Ranjan Rautray, Learned Counsel, appearing for the opposite party number 3, University, shall take instructions as to if, as regards the status of the representations submitted by the petitioner on 15/1/2013, bracket annexure 8 to the writ application. Just you obtain instruction and we'll see. You may say that no action has been taken. It will be easier for the court to then dispose of.
No, my lord, I will not say. I will say them take steps on that representation, my lord. Why I will say?
Yes. Whatever.
Your lordship is passing an order. May I to that, your lordship may grant 2 or 3 days more time. As because representation is of
7th May. But this will be a parted matter.
My lord.
Item 22.
Ketra achi? The petition? Yes. Chief, in item 22, I am appearing for OP number 3, the principal and secretary of the institution. OP number 3, opposite part number 3, your lordship. Yes. Who is he? The principal come secretary of the institution. Principal come secretary. College. After 2000, there are 2 principal come secretary. What a fund.
OP number 3 is he is appearing for.
I am for OP number 3, your lordship. So that plus 2 college.
High secondary school.
Yes. You have filed your counter? No. I have not filed my counter since last night. I contacted the OP number 3, and I was informed that he has retired in the meantime. And
myself.
No.
Oh.
OP number 3.
No, that's a post. Well, how can
there must be some principle. Agreed, my lord. But since I need to also file the counter, so therefore, what is the threat? They are challenging annexure 4, wherein
some area dues are being to be paid. They accordingly, this is the 3rd round litigation before my lords. Thereafter, the honorable court directed, your lordship, the last order was passed. That was on WBC 20551 of 2011 was decided by this honorable court on 2nd of March 2021. A collateral bench of this honorable court has directed that the matter is to be taken considered by them and Mr. J. Bishop, your office. So they were directed that they must have to comply the orders. Whether they have complied or not, let him get the benefit.
So this is 501.
No, it is 3rd round, sir. 2nd round is 20551 of 2011.
Let him take instruction and file a counter.
Yes,
my lord. Sri Shekhar, counsel, what Shekhar, your name is S. Shekhar. S. Shekhar, which office do you belong to?
Bhubaneswar authorized office.
On behalf of SK Samal, since my name is not reflected in the SK Samal. Samal, my lord. Yes. ठीक है, Sri S. Shekhar, you are before us, that's all. Sri S. Shekhar, Learned Counsel, appearing for opposite party number 3, my lord. Seeks some time to file, to obtain necessary instructions and to file a counter affidavit if necessary. Let this matter on 7th May. Yes. Counter affidavit, if any, be filed in the meantime positively.
Yes, my lord.
Item 23.
23. Dispose of that. Put a pass over for the dispose of. Yes.
Item 24.
The Kalithala. Yes.
May I please, your lordship? You'll also kindly come to page 32.
So that the plucking of cotton. I had asked you to find out, see, this is a finding of fact. You have the file, entire file.
Yes,
Along with depositions and everything.
yes. Whatever the documents are relied upon by the authorities collected during the inquiry and the subsequent inquiry stage, my lord, after the metro.
So I had asked you, this is a purely a question of fact. Why should the court interfere? Finding of fact rendered by the competent authority.
My lord, so far the CWC has submitted the intimation to the collector, asking the DO to find out this and to give a report. That is what they said is complaint encounter. Then that incident was took place on 13/1. They have rescued the children, they say. And on 12/1/2015, the BWO directed to ADW here to go to school and to make an inquiry. He visited on 13/1/2025 and inquired about the matter. There he took the statement of the petitioner. Relying upon that and on the basis of the intimation of the CWC, the very next day, collector asked the disengagement order without initiating any discipline. Even the CWC has not inquired into the matter. They said that DO to look into the matter and to submit a report.
In the Sikha Sahib, you were appointed while you were appointed, you had executed an agreement.
That agreement, your lawsuit can see. That is what I'm telling. I just want to take an disengagement order, page 32.
So only the principles of natural justice have to be followed.
My lord, just a minute.
No, yes.
I'll come.
Yes.
My lord, page 32. Annexure 5.
32.
Annexure 5.
Yes.
Page 32.
Yes.
This is the disengagement order passed the very next day. The insurance protect my inquiry was made at 3:25 and basing that inquiry without giving any notice to us. This order.
You were satisfied the court. Had you been given an opportunity, what further you could have stated?
That's what I'm telling, my lord. I'm just taking your lawsuit.
Yes, please, quick.
Annexure 5, my lord, your lawsuit can see. Whereas the Babura Himika, son of Sonso of Matikona EPFC under Rayagada block has committed criminal act of engaging 17 children, 14 plus and 3 boys on the same school in using them as levers for plucking of cotton in his own field at Bakuruguda 08 km away from their village for at least 3 days till they were rescued by the Children Welfare Committee on 13/1/2015. Whereas the Babura Himika SSPFC Matikona has violated the conditions of the engagement or condition of the engagement through agreement he had executed on 4th May 2000 at the time of engagement as Shiksha Sahayaka and posted in PUC Rayagada block. Now, and in view of deliberate gross violation of the right to education of children guaranteed to them under the RT Act 2009, committed by Sri Babura Himika, the undersigned being the appointment authority of Sri Babura Himika, Shiksha Sahayaka Matikona PFC at Rayagada block, after perusing the complaint and inquiry reports, madam, and considering the gravity of the charges, order for his immediate disengagement from service with effect from 14/1000 under SSA as per clause 11 of the terms and conditions of the agreement. Your lawsuit come to the reports. This is complaint and inquiry reports. Then clause 11, I violated. Now your lawsuit come to clause 11 of the agreement. What does it say? My lord, that's page 26. My lord, page 26. Your lawsuit, that the first party, my petitioner, shall be liable to criminal proceeding and disengagement from service if any of the documents, certificates, or facts produced by him or her are found not genuine and false.
Please come to page 23.
This is 26, my
You please come to page 23, sir.
Yes, ma'am.
Come to clause 11. Please place it, sir.
That in the event of the violation of terms, in the order they said agreement of it. In the event of the violation of terms and conditions here is specified, he or she may at any time before the expiry of the contract period resign and the contract of adjournment will be decided. I'm not disputing this matter. They said this I have violated the terms and conditions clause 11, and they said that is inquiry reports. Whatever I find from the report, and I have supplied the CWC, that's the only intimation. And they asked for DO to examine that also.
The only thing is here, Mr. Patnaik, what I find is what I find is the impugned order, the order of disengagement was passed on the orders of the collector. Now he himself has the grievance petition.
He himself has?
He has passed the impugned order, which is his grievance, the grievance petition, which he disposes of, isn't it?
No, my lord. In fact, my lord, the
order was passed by the district project coordinator on the order of the collector, disengaging him.
That was the first order.
That was the first order, yes.
Then he approached before this Honorable Court. Honorable Court found that since in terms of that particular clause number 10 or 11 of that agreement,
he has not been given an opportunity.
He has not been given an opportunity. The matter is remitted once again to the government of the collector to examine the matter and to conduct an inquiry and to give opportunity.
So thereafter the collector gave him opportunity.
Thereafter the collector gave the opportunity. Noted down the depositions of the respective parties, took into consideration the different reports which are produced, and not only that matter. This is not only this particular petitioner, but also the headmaster. He was also taken to the tax matter. He was also proceeded in this case.
All right.
But since it is the petitioner,
so I get your point.
Yes, ma'am.
My query is answered. Now, once the matter is remanded to the collector and collector conducts a hearing, granting you opportunity of personal hearing, in which your deposition is recorded along with the deposition of the ABEO.
Yes, ma'am.
Lakshman Murthy.
Yes, ma'am.
All right. Then how, this is a factual finding of fact. How do you challenge it?
That's what I'm telling us. This court has remitted matter to the collector for the consistent giving opportunity. I have given opportunity, there is no doubt of it. And what did the collector do? He has taken an oath and he quoted whatever the inquiry report submitted by ABO in his report, para 2-3, and ABO was examined. But actual, whether I've got that lane, whether they have examined this, whether the ABO have taken inquiry about from the headmaster or any of the teachers apart, or any of the ward member of the college, or the parents of the students. And they have never given complaint. The student never given complaint, the parents never given complaint, and they have also approached to the collector that he is not default. He is not having land, and also that also they have enforced. So at best, even take for an assumption that he has acted criminal, engaging this 17 poor children. So at least a discipline proceeding should have started in suspending or something like that. But direct the very next day.
You're a contractual employee.
Whatever it may be. Very next day, without. And
so that is gone, sir.
Even after remand.
That part is gone.
Even after remand also the same order was passed.
No. You mean to say that he should have heard the parents. He should have taken note of the fact that he claims that he doesn't have that land.
Yes.
He is not the owner of the land.
Yes.
All these aspects have not been considered. But where was the plea taken by you?
Yes.
Let us see. Where is your representation before the collector?
Representation of the collector I have not. I have just given that copy of this order.
No. Copy of you must have given a grievance.
That is. But I have 6.
Annexure 6 you cannot better your case. What is in your grievance petition that you have to see? ଗ୍ରାମବାସୀ ବୃନ୍ଦ ଆପଣଙ୍କ ଅବଗତ ନିମନ୍ତେ ଲେଖିବାର ଅଭିପ୍ରାୟ ହେଇକି ଯେ ଆମେ ମାନେ ଆର୍ଥିକ ମାନଦଣ୍ଡକୁ ଗଲା ଏମାନେ ଏଇ ଯୋଉ ନେଗେଟିଭ ଗୋଟେ ଆଣିଛନ୍ତି ରିଭର୍ସ ଏଭିଡେନ୍ସ ସେମାନେ ସେମିତି କିଛି କରିନାହାନ୍ତି ବୋଲି.
Even my lord, your lordship kindly go to this prosecution. That's an order also. There it says, my lord. Only I'm taking.
Even my lord, one proceeding was also initiated at the level of the Human Rights Commission, my lord.
No, It is only, it is only happened the very next day, the collector was surprised because of the, it has been by through electronic media printed because of the enmity of the some petitioner.
Where was the earlier writ application? Let us see what was your pleadings there.
Earlier writ application.
Is this matter what date color?
30th April.
30th April, along with the WPC number 1119 of 2020, bracketed disposed of on 17/5/2012, and WPC number 17073 of 2015, bracketed disposed of on 16/10/2015. We want to see what pleadings were what were your pleadings in the other writ applications, number one. And did you submit any representation or grievance petition to the collector against the order of disengagement?
No, my lord, I have not submitted. I have not submitted.
All right.
That's
It will come on 30th, we'll see. Yes.
I have not submitted.
All right.
Item 25.
Yes.
Sir, item number 25.
Yes.
Sir, Srinivaskar. WPC number 3797 of 2021. Sir, I'm 75% physically handicapped petitioner. In person. Sir, I have lost my left eye since birth. Accordingly, I am 75% visually handicapped. Sir, I was selected on merit in serial number 2 for the post of Shiksha Sahayak under Nishchan Kohli block of Cuttack district as per the advertisement dated 14/10/2006. But I have been debarred from engagement due to administrative fault and negligence in duty of the district administration, violation of 80-point model roster prepared by GA department, and wrong procedure of appointment and irregularity in engagement.
कौन है जी?
Sir, पेज नंबर 10 सर देखोगी.
Yes.
Feasibility
certificate. Yes.
पेज नंबर 11 Odisha Teachers Eligibility Test OTET.
Yes.
Conducted by Board of Secondary Education Odisha. Sir, page number 11 and 12 Diploma in Elementary Education. Sir, page number 13 ରୁ sir page number 19 Matric ରୁ +3. Sir, page number 20 Annexure 2. Sir, ଏଇଟା ହଉଛି merit list approved by collector cum chief executive of Cuttack. Sir, ଏଇଠି ଟିକେ କହିବି sir, serial number 1 ରେ ଜଣେ ପିଲା ଥିଲା. ତା ତଳକୁ serial number 2 ରେ ଥିଲି ଶ୍ରୀନିବାସ Sir, ଗୋଟିଏ ପୋଷ୍ଟ ଆମର ରିଜର୍ଭ ଥିଲା 80 ପଏଣ୍ଟ ମଡେଲ ରୋଷ୍ଟର ଅନୁସାରେ ରିଜର୍ଭ ଥିଲା. ନିଶ୍ଚୟ ପୋଲି ବ୍ଲକ ଅଣ୍ଡର ଥିଲା. Sir, serial number 1 did not turn up for engagement. Accordingly, I was entitled to one post reserved for the visually handicapped category.
He was 100% visual. That other person.
Serial number 1 was 100%
visually handicapped.
Handicapped. Sir, he did not participate in the process of engagement. Accordingly, serial number 2 myself was entitled to one post. Sir, तापर मु बहुत चेष्टा करी सर डिपार्टमेंट को कौन से कथा सुनिबा को राजी
आपण मेरिट लिस्ट होला पर एंगेजमेंट ऑर्डर दिया गला नहीं
ना ना अंतले
तापर कोन हला
हां कहू सर सर पेज नंबर 22 देखंजु
22 यस
सर 1/14 मध्ये रे
80 पॉइंट रोस्टर
हां 80 पॉइंट मॉडल रोस्टर एटा सर आरटीआई डॉक्यूमेंट पब्लिक इंफॉर्मेशन ऑफिसर सर्वशिक्षा अभियान कटक सर 1/14 संख्यक पदवी मध्ये रे जने 1 पर्सन फ्रॉम पीएच ब्लाइंड पाइबा कथा सर पेज नंबर 23 देखंतु मु आरटीआई रे मागिथली जे निश्चय कोली ब्लॉक अंडर रे 2006-7 रिक्रूटमेंट ईयर रे काहाको देइछो कुहो से मना कले जे आमे नो फिजिकली हैंडिकैप पर्सन हैज बीन एंगेज्ड ड्यूरिंग द रिक्रूटमेंट ऑन ईयर 2006-7 अंडर निश्चय कोली ब्लॉक सर पेज नंबर 31 पर्सनल सेक्रेटरी टू गवर्नर in its letter dated 19/8/2019 has requested the additional chief secretary to government school and mass education department to take appropriate action
Yes.
Sir, page number 32, Office of the Chief Minister, Joint Secretary to Chief Minister has requested the opposite party number 1 to re-examine the case as the visually impaired petitioner has been debarred from engagement without his own fault. Sir. Sir, page number 34, Additional Secretary to RDC, Central Division, Odisha, Cuttack, has requested the opposite party number 1 to consider my appointment on the ground that the first candidate in the selection list did not turn up for appointment. And 80-point model roster has been completely ignored. Sir, page number 35. Sir, ସେତେବେଳେ ଡେଭଲପମେଣ୍ଟ କମିଶନର ଥିଲେ ଆର୍ ବାଲକୃଷ୍ଣନ, ତାଙ୍କୁ ଯାଇକି ଭ୍ୟାନ୍ସି ଭେଟିଛି ସେକ୍ରେଟାରୀରେ। ସାର୍ ସିଏ ମତେ ସବୁ କାଗଜପତ୍ର ଦେଖିଲେ କହିଲେ ଆଉ ତମର ତ ହେଇନି, ବହୁତ ଲେଟ୍ ହେଇଗଲାଣି, ଆଉ ମୁଁ ଫାଇଲଟା ଲ ଡିପାର୍ଟମେଣ୍ଟକୁ ପଠଉଛି। ତେବେ ସାର୍ ଜଣେ ରାଉତରାୟ ସାର୍ ଥିଲେ ପ୍ରିନ୍ସିପାଲ ସେକ୍ରେଟାରୀ, ସାର୍ ସେ କହିଲେ ଲ ଡିପାର୍ଟମେଣ୍ଟକୁ ଫାଇଲଟା ଗଲା, ମୁଁ ସେଠି ବି ସାର୍ଙ୍କୁ ଭ୍ୟାନ୍ସି ଭେଟିଲି, ସିଏ କହିଲେ ସେ ଠିକ ଅଛି, ତମର ତ ଜେନ୍ୟୁଇନ୍ କେସ୍ ଲାଗୁଛି, ମୁଁ ଦେଖିବି କଣ ହେଇଛି। ସାର୍ ପେଜ ନମ୍ବର 38 ଦେଖନ୍ତୁ ସାର୍, ଲାଷ୍ଟ 2 ଲାଇନ୍ ଖାଲି, there is no legal bar for consideration of his case for appointment to such post of ଶିକ୍ଷା ସହାୟକ। ପେଜ ନମ୍ବର 38। Sir, page number 39, Deputy Director, Odisha Primary Education Program Authority has admitted the fact that Sri Poro has applied for the said post during 2011. এটা totally collector admit କରିବାକୁ ରାଜି ନୁହେଁ, କଲେକ୍ଟର ଅଫିସ ରାଜି ନୁହେଁ ଯେ ନା ତମେ 2011 ଆପ୍ଲାଏ କରନ, ଆମ ପାଖରେ ଫର୍ମ ନାହିଁ ଆଉ ଇଏ ନାହିଁ, ସେ କହୁଛନ୍ତି ଦୁନିଆ କଥା ଗଲା। ସାର୍ এইটা হচ্ছে পেজ নম্বর 40। স্যার এই সবুঠু ইম্পর্টান্ট স্যার, দিস annexure act is related to paragraph 10 and this is very important for this writ application. Sir, some candidates have been appointed as শিক্ষা সহায়ক under Jilla Parishad Cuttack in the year 2009, 2012 and 2018 from the selection list of 2006. Sir, page number 40 and 41, Pradipta Kumar Swai has been appointed as শিক্ষা সহায়ক under Jilla Parishad Cuttack with reference to engagement order dated 23/5/2009. The said candidate has been engaged in the year 2009 from the selection list 2006, that is after 3 years from the year of approval of the selection list. Sir, another candidate, Kumar Bhoi.
ଛାଡ଼ନ୍ତୁ, we accept it। ତାପରେ ଛାଡ଼ନ୍ତୁ, ଆମେ ଆକ୍ସେପ୍ଟ କଲୁ, ଜଣଙ୍କର ଦେଖେଇଲେ ହେଲା, ଠିକ ଅଛି।
ଆଉ 2 ଜଣ ଅଛନ୍ତି ସାର୍,
ଦରକାର
ସାର୍ ଗୋଟିଏ ଟିକେ ସାର୍। Letter number 44, one candidate, another candidate Basant Kumar Sahu has been appointed as শিক্ষা সহায়ক under Jilla Parishad Cuttack with reference to School and Mass Education Department letter dated 31/7/2018. The said candidate has been engaged in the year 2018 from the selection list of 2006, that is after 12 years from the year of approval of the selection list. Sir, ଆଉ କଣ ଯାହା ବିଚାର କରିବା।
କାଉଣ୍ଟରରେ କଣ କହିଛନ୍ତି?
ସେ କାଉଣ୍ଟର କିଛି ଆସିନି।
ଗୋଟେ ଅଛି
ସାର୍ କାଉଣ୍ଟର ଆସିଥିଲା।
filed by on behalf of opposite party number 3, district education officer has filed a counter.
ହଁ ସାର୍ କାଉଣ୍ଟର
ସ୍କାନ କରି ଗୋଟେ କପିଟେ ଦିଆଯାଇଛି, କିନ୍ତୁ ମୁଁ ସାର୍ without the counter even may submit one.
Yes.
ସାର୍ କାଉଣ୍ଟର
This is with respect to the selection and
2006.
to the 2006. When the petitioner was debarred from getting the appointment ballot, then he appealed before this honorable court.
There are 2 orders that I find.
Yes, ma'am.
Yes.
And my lord, in both the cases, the first case, that is the before the honorable single judge matter, that is at annexure
Justice,
note 25.
Honorable Justice S.K. Mishra as his
Yes,
as his lordship then was.
and my lord, the operative portion, my lord, at note 28, para number 5. Then this order was challenged before a division bench.
Why was it rejected? On what ground? I have not gone through. Why was it rejected?
In fact, my lord, the previous para says, my lord, that it was a selection for the year 2006. And
let us read the order. No, let us read the order.
Yes, ma'am. My lord, may I be permitted? This is the last one, my lord.
Last two.
So in this case, my lord, Para number 5, pay note 28, my lord.
No, I think,
Want to,
I don't understand why. Because there was a requirement in the, that 80-point roster to have one visually challenged candidate
yes, ma'am.
among the first 14. 1 to 14 bhitar jana rahiya darkar.
Yeah.
According to him, according to Mr. Kora, the other person who was 100%, he did not join.
Yes, ma'am.
He was selected, he was number 1, but he didn't join.
Yes.
So naturally one would think, so why was it rejected? The earlier writ application, let us find out. As per circular issued by the EA for engagement of blind candidates for such should be strictly followed. Stood second in the physical event, no? Those are the validity had expired.
Yes.
That is what they
By
heard.
the time, my lord, when this case was decided, during the year 2012, another advertisement under 2011-12, my lord, that was already in progress.
Not for me to say anything here.
But my lord, my submission, my lord, once this is a clear-cut observation with respect to the candidature of the petitioner and the petitioner being agreed with this order, he approved before the appellate court, my lord, and annexure 5.
The writ appeal order.
Yes, ma'am. There it has been dismissed. And that was in the year 2015. And reasons have been assigned, my lord, why it has been dismissed.
Because the select list was of the year 2006 and subsequently another advertisement was issued. But in between he had approached, isn't it? In between he had approached the court. Anyway, for whatever reasons.
But my lord, my limited submission, my lord, at this juncture, after these two orders, which are also annexed by the petitioner in his written.
He has, yes, fairly admitted.
Yes, ma'am. But any cause of action for the that is the maximum the my lord which can be.
Yeah, direction can also be issued basing on the law department's opinion and on his assertion that some other persons from that earlier list, this Pradeep Kumar Samal or somebody, no, Pradeep Kumar Swain, they have been appointed. Yes. But it is nowhere mentioned that someone 2006 applicant is they could have someone subsequently to advertisement is apply करते पारंती someone successfully they
solve by sir. These are solved by it.
नहीं 2006 रे ସେମାନେ थाई पारंती କିନ୍ତୁ ଏଥିରେ ବି ସେମାନେ apply କରିଥିବେ ସେଥିପାଇଁ ପାଇଥିବେ but ୟାଙ୍କ କେବଳ ଗୋଟେ କଥା ହେଉଛି ଯେ law department has given an opinion, so that is a distinguishing feature or change in circumstance.
Distinguishing that cannot have a claim against 2006, but because 2010
the government has changed its stand. Government has this he had approached this court. The single bench decided that he is not entitled. The division bench confirmed it, but subsequent to that, yes, the government has changed its stand. So the government has to consider.
Yes,
government can consider.
To that extent, my lord, I cannot say no. No, because that the favorable opinions are there, my lord, there are. Yes. But with respect to his claim, as he has claimed in this particular.
So why don't you take instruction? I'll grant you only one opportunity.
Yes.
All right. In course of heard Sri Srinivas Koro from other petitioner in person and Sri S.N. Patnaik Learned AGA. In course of hearing, it is brought to the notice of this court that a coordinate bench in WBC number 5481 of 2011 had dismissed the writ application filed by the petitioner praying for direction to engage him as Swechhasevi Shiksha Sahayak as per the advertisement dated 14/10/2006. The writ application was appears to have been dismissed basically on the was not entertained on the ground that the selection of the year 2006 was followed by initiation of another selection process in the year 2011. Stop. The petitioner preferred an intra-court appeal being WA number, writ appeal number 298 of 2012, which also came to be dismissed by order dated 9/1/2015. This court, however, finds that pursuant to representation submitted by a grievance submitted by the petitioner in the grievance cell of the Development Commissioner, come Additional Chief Secretary Orissa, the matter was referred to the Law Department. Being thus referred, how did you get this opinion? Law Department's opinion?
Sir,
आपने किन पहले Law Department opinion?
सर मुझे डिपार्टमेंट को जाए स्कूल में आसू जाए
Officially किन पहले आ गया?
ऑफिशियल ने आक्टिव मागिन सर এটা ডিপার্টমেন্ট না স্কুলের মাস এডুকেশন না
It is submitted that Law Department has tendered a favorable opinion to the effect that there is no bar for consideration of the case of the petitioner for appointment to the post of Shikha Sahayak against the vacancy pursuant to advertisement of the year 2010. Stop.
Yes.
Then State Council shall produce the opinion of the Law Department and also take instructions in this regard. List this matter on 30th April. 30 ଆସିବ ଆଉ ଥରେ.
Sir, May ମାସର first week ରେ.
7th May ତାହେଲେ 7 May.
Most of it.
ଆପଣଙ୍କର ଏଜ୍ କେତେ?
ଗୋଟେ ସାରେ
53 ବୋଲି ସେ ଲେଖିଥିଲେ.
56 ଏବେ 56
ହେଇଛି.
ଠିକ ଅଛି.
Item 26.
Find out if you can be adjusted anywhere. Adjust କରିଦେଲେ ଯିବ.
In a copy of this particular order.
Free copy of this order be handed over to Sri Patnaik for compliance.
Item 26.
Yes, Mr. Mahathi, somebody was requesting for time. Since you were not there, I asked him to. You want some time?
Any other day.
All right. As requested by 11 counsel for the opposite party, list this matter on 30th April.
Item 27.
Please, yours. Last time, Lordship directed to take instruction, government, further instruction regarding investigation of the matter. On the date of a surrender before the Law and Court below, another FIR is registered for assault for the
Transfer matter?
Lordship transfer the criminal proceeding from Umar Court to Nabarnpur Mile.
Oh, that is what you want?
Your Lordship. One FIR is registered by the wife. As per the FIR, this one was directed to surrender before the Law and Court below. When I surrender on the same day, they have been assault me on the road, block the road and assault me.
Yes. What is your instruction? ଆଜ୍ଞା ଛାଡି ଦିଅନ୍ତୁ ଷ୍ଟେଟ୍ କାଉନସିଲ କୁ ଛାଡନ୍ତୁ ଜାଗା ନୋଟିସ ଯାଇନି notice to opposite party has been delivered, there is no offense anyway. So they had lodged an FIR, Umar Court PS case number 54.
Yes, my lord. That PS case number 54 dated 21/24 under section 341, 294, 323, 350. Investigation is going on, my lord.
The learned State Council has obtained instruction that Umar Court PS case number 54 of 2024 has in fact been registered at the instance of the petitioners.
Yes.
And that investigation is going on. He shall inform the court regarding the further progress of investigation in the matter. List this case on 7th May.
Public.
Therefore, if you find that some truth comes out, then we'll transfer it. Okay.
Item
Public.
28.
I may plead, Lords. I am on behalf of Mr. Naik. He has some family problem. He requested me to submit it before Lords on his behalf.
Alright.
And a petition on session 24 CPC.
Go to it. As directed, the learned judge, Family Court Kendrapada has informed that video conferencing facility is available in the court premises for appearance of the parties through virtual mode. Stop. Yes.
Previously, my lord, preferred as TRPC 59 of 23, my lord.
Yes, that is.
And this one only court directed. Honorable Chief Justice, my lord, the petitioner is permitted to make a request to the family court concerned for appearing virtual mode and the proceeding to be conducted virtual mode.
Yes, that is annexed. That is already annexed.
My lord. So who is seeking transfer?
Wife.
You are the wife.
My lord.
What is this matter? Divorce? So you want it to be transferred to?
To Bhubaneswar.
To Bhubaneswar. Because you are residing at Bhubaneswar.
My lord. DB case and another criminal case 498.
Okay. And what about settlement? Any possibility of settlement?
There is no settlement. So
no, there no settlement so far. But would you like to go through the process of mediation?
My lord, if it is a transfer from Kendrapada to Bhubaneswar,
transfer mediation.
possibility of settlement?
No. Now, right now, if your intention is bona fide, if you think that the matter dispute can be resolved amicably, then I will send it to mediation, keeping this pending.
My lord.
Yes, what do you say?
Yes, my lord.
Yes?
I'll take instruction, my lord.
Instruction from who? The sanction mediation, whatever, I would mediation center, both parties will appear. If it is settled well and good, all the matters will be disposed of. If it is not settled, then we will consider.
My lord.
Yes,
it is stated in course of hearing, it is stated at the bar that the nature of dispute between the parties is such that an attempt can be made to resolve the same amicably through mediation. Stop. In such view of the matter, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. Stop. The parties are directed to appear pursuant to notice received from the mediator and to render full cooperation in the mediation proceeding. So let's this matter on 21st May. Till such time, interim order to continue.
Yes.
First you try. If it fails, then transfer application will be considered. Item
29.
29, yes.
May I please, Lord?
This office note as above may kindly be repeated. Notice and issue undelivered. No notice. As per the postal tracking report, my lord. Let this matter. Let the postal tracking report be back to the case record. Let's this matter next week.
So item 30.
Item 30.
Kindly see the paragraph 12 of the petition.
Mr. Pushti submits that his client is ready and willing to live peacefully with his wife. You wanted to take instructions.
Yes,
on his submission that she is ready to reside with you peacefully.
No, she is not ready to reside with you. Both for the petition of abhorrence.
In the last occasion, your lordship had this matter.
Whether the matter can be referred to mediation for settlement.
Yes, my lord.
What do you say?
Mediation को accept में राजी हो चे, my lord the direction.
No direction, there is no force, there is no coerce. It is up to you.
Top court को चे, ताको legal expense देले चे ऐसो, तार किच्छी नहीं.
Yes, what do you say?
Nama bhul kata sabu siege matter destitute lady my lord.
No, not a question of destitute.
There is a possibility of settlement.
So pay some money for her to come to. Where are you staying?
Keonjhar.
Keonjhar. Where are you staying?
I am staying in Kendrapada.
Age also.
So you are Keonjhar DLSA.
Yes,
I will ask the DLSA Keonjhar mediation will take place in Keonjhar.
My lord, kindly give my petition.
If you are not in
Paragraph 6.
please. If you are not unable, if you are thinking that she is not a destitute, so you don't have to pay to her, you don't pay, you come. You come, we'll fix it at closure. Correct. In view of the previous order, the parties have taken necessary instructions.
See the paragraph 6, once DLS was mediation was there.
How did it address? How did it address?
Notice on opposite party appears to have been served, but there is no appearance. Learned counsel for the petitioner requests for an adjournment. List this matter on 30th April.
Item 32.
Interim order to continue.
May I please election?
32, we are filing the counter and solving the copy of the counter.
You waiting for the nth moment to file serve the copy, Mr. Das?
No, it was filed only yesterday. He filed.
All right.
Hard copy may be accepted.
Learned State Council files counter affidavit in court after serving copy on the other side. Who wants to go through the same to make to respond thereto? List this matter. When?
Any day else.
7th May.
Item 33.
Yes.
May I please? Petitioner is working as a Anganwadi worker since 16 years. By Annexure 1, the ward member lodged a affair that I put her signature in the check and ordered the money. There was an allegation. And the sub-collector disengaged me from the Anganwadi worker. Then I challenged the same before the collector. Collector, kindly have a glance. Collector called for a report from the bank. Whether the collector passed the order and confirmed the order of sub-collector and disengaged. So this order court took a view and said that kindly consider whether this report, report has been considered before the collector or not.
No, letter dated 3/11/2023 of the UCO Bank.
Yes.
Whether it was placed before the collector or not. That is what the court wanted to know.
Yes, your lordship wanted, but that specific
instruction you must obtain. That has got a material bearing on the outcome of this case.
Yes.
But not in the nothing else. Can I have a glance? Annexure 8. Reply in the matter of organization number 16 of 2000.
Before this court can render a finding that the record that the letter was not considered, it must be sure that yes, it was on record and then not considered.
Yes.
If it is on record and not considered, then it has a different way.
And
So
that
let
is
it-
the instruction.
that is why, yes.
And the like.
As requested by London State Council, is this matter on 30th April? Order dated 2/4/2024 be complied with positively. No, देखो time on देखो नहीं ये देखो
Item 34.
Item 34 can pass over, my lord.
Item 35.
My lord, kindly pass over.
मेंशन करथिले
It is
All right, pass over.
a matter in
देखो ऊपर देखिए
So item number 12.
Last order.
Who is opposing you, Mr. Das?
State. Why?
With the endorsement made in
There is
service
an order to
election.
later. Because my client is not in a position to collect. If my friend will give some individual, then it can go later session.
Office order dated 18/10/1976 as also the relief order.
Yes. From the government institution to private institution.
I'll collect it.
As requested by Learned AG, is this matter on 7th May? Office order dated 18/10/1976 and the relief order in respect of the petitioner be obtained, be produced for perusal of the court. Yes.
I don't know. 93 or
Item 13?
item 14.
No, 14. Item 14 is yours, Smita.
Yes, ma'am.
Again, state is opposition.
Yes, my friend is stated yesterday.
What is that, ma'am?
This is that claim is for on trend scale and trend scale. The fact of the case is, my lord, my services were terminated. I was during the institution during the period the institution was unaided. Therefore, I had filed an appeal before the regional director, who is the competent authority. I succeed in that case, and here it is the specific finding that I deemed to be in service. So therefore, I was supposed to be allowed to the institution, but I was not allowed. Thereafter, I approached this honorable court for implementation of that order. In the meantime, I have filed also a case in the tribunal because I am also because in the order is of 2003, and from 2004 the institution became scheduled. So I filed a case in the tribunal. Tribunal also I succeed. That was the case was contested, and direction was issued to pay me on trade scale because at the relevant time I was on trade because my initial appointment is 1992. Judgment of this honorable court in the Vivekananda Das case was before 18/12/1993. If somebody is appointed, on trend is also due. So direction was issued. That order, again I filed a petition, writ petition for implementation of that order also. There the honorable court interfered and direction was issued to allow me to work as also to give me the benefit. It was implemented. Implemented in the sense the inspector of school says, because we are implementing 2010, you will get your salary from 2010. That is why I have come to this honorable court. And in this case, but in the meantime, they have challenged that tribunal's order in a FAO. That is FAO 6 of 2007, which was also dismissed very recently on 29/3/23.
We'll bring that order, right? We'll bring that case record.
So that has also been dismissed. FAO, only one line order because it has been implemented partly. So now in this particular case, my prayer is twofold. From 1/1/2004 to 2010, the area in the on-trade scale, and I became trained from 10/3/2014. I passed B.Ed from IGNOU. That is why I produced the certificate. So after I became trained, I want that I must be paid the graduate scale of pay. Yesterday, my friend's submission was, since I have accepted Annexure 1 and I have not challenged that, I am stopped to claim for any arrears salary. That is the first submission. My response submission to this is, let's see Annexure 10. Let's say Annexure 1, page 10.
Yes.
I'm just reading out a small order. Pursuant to the order, Government Department of School and Mass Education, in letter dated 24/6/2010, with a copy of the Inspector of School Mayurbhanj in memo dated 24/6/2010, arising out of order dated 3/2/2006, passed by the State Education Tribunal in JICase 136 of 2004, read with the order dated 25/9/2007, passed by the Honorable High Court in WPC 863 of 2007, Sri Ajit Kumar Mishra, BSc CVZ, on trend, appointed by the Managing Committee of Jhadeshwar Vidyapita Khanua as assistant teacher against TGT post, is hereby allowed to join in the school immediately to be entitled to get the block grant in on-trend scale of pay from the date he joins in duty. So if an order is passed pursuant to the court order and court never says that from the date of joining I will get the benefit of salary, I will not be entitled to the back wages, then my lord, it is all right. But this is an order, what he says, he has referred to the court order. So if the court order says that a thing is to be done in the particular manner, he cannot say that it will be done in, that is why I filed this case. Because by this order, he passed two orders. I am allowed to join and I have to get the salary. So only thing I responsibility.
Tribunal's order?
Yes, tribunal's order in the counter he has given, I will file it. In the counter, my friend has given it. Order is page 34. Last ordering portion.
Annexure तक होगी ना?
Annexure सेटा आई थला काली पेज का मिशन होता आई
तो होगा नहीं क्या?
काली मिलनो थला आई
हाँ अच्छी सेटा Annexure G जो उटा थी ये केस ना 136
आगे सेटा इट लेके चले आई से
अजीत कुमार मिश्रा तो
आगे yes. The case is allowed on contest but without cost. मुकल ordering portion टा पूरा. Annexure 5 is quashed. The opposite party 1, 2, 3 shall approve the appointment of the appointment applicant and shall give him grantinate has an on-trend scale within a period of 3 months from communication of copy of.
So what is the purport of this order according to you? What will be the purport of?
There was an appeal order Annex of 5 wherein it was denied to me. Annex of 5 was.
So the tribunal says that you are entitled to on-trend scale.
On-trend scale of. That was the purport of this order. And so far the order of the restatement is concerned.
The Annex 1.
No, actually, if my lord will permit, I will file it. Yesterday I was reading it from the previous writ petition. If my lord called for 860307, it was filed, wherein direction was issued to implement that order.
Why don't you file it here?
Again?
You can file it here also. If you want to, you can file it by way of a memo.
Yes,
the court can consider it.
Yeah, but the order is there.
So now Annex 1 is impugned.
Which one?
Annex 1 is impugned.
Not exactly impugned. I say that because there he says you are approved, you will get it from today. I say let my arrears salary be paid. That is my prayer. Because if I challenge this, then I will not get even the whatever they are giving now. I am not getting. The person is now getting only 4,500 rupees. Therefore, yesterday he came to me. This is his salary today. Though other teachers are getting about 50,000-60,000 now after this gratuity and all this thing. He's a graduate teacher. Now,
so what is the stand taken by them?
There's very peculiar stand. This inspector of school has filed this counter challenging my appointment order. That means he is now the appellate authority of the High Court order, Tribunal's order, and his regional director's order. Past the regional director, the appellate authority directing reinstatement of my service. Notwithstanding the fact that I was on train. High Court order to implement the order. Notwithstanding the order, I was fact that I was on train because of the Viganda's case, that 867. Tribunal's order also referred to that Viganda's case and directed on-trend scale of pay. But this irrespective of school now, he is there to file this affidavit to say, no, because in another case, there is additional section teacher case, Supreme Court has said on-trend cannot be appointed, so you will not get it. No, but when my orders have reached a finality, by the dismissal of the FAO, by allowing my appeal by the tribunal, I have succeeded in the appeal with regard to my termination and the writ petition 867 of 2007 of this Hon'Ble Court.
So let us see the counter. Which order of the Supreme Court is he referring to?
Peculiar. Is it acceptable now at this juncture? Kindly see, he referred to case Balaram Tripathi, page 16 में kindly see.
Page 16, internal page.
Again, counter.
Counter affidavit filed by Purnachandra Sethi.
Yes. The
internal page 16.
16 last paragraph. The judgment dated 8/1/97 of the Hon'Ble High Court passed in OJC number 370 of 96. Balaram Tripathi versus State relied upon. Balaram Tripathi was appointed as assistant teacher in Gopabandhu Uccha Vidyapita Balangir by MC in the year 1984. At the time of the appointment, he was overaged and untrained. And as such, his appointments were not approved by the inspector of school concerned. Being agreed by Tripathi filed a petition in the Hon'Ble High Court in OJC 370 of 96. Hon'Ble High Court dismissed the petition on 8/1/97. The Tripathi filed SLP civil number 22 in Apex Court. Hon'Ble Apex Court in their order dated have also dismissed the SLP. The School and Mass Education Department of Orissa circulated among all concerned by letter dated 4/4/2000 that the appointment of the untrained and overage candidate appointed by the managing committee in non-government rated schools shall not be approved as per the government letter dated 4/4/2000 annexure F to this counter. So this is his stand. If I want my response submission to this is, this case has nothing to do with my case because my orders of the appellate authority is the in their own hierarchy, regional director is a higher authority than this due. He has reinstated me. State Education Tribunal, headed by a senior judicial officer, and the statutory court. He has passed an order in my favor. That order was challenged by them in a favor that is also dismissed, taken that they have not gone to the Supreme Court. Writ petition, I have filed for implementation of all these orders. Direction was issued and accordingly you have implemented the order. Is it now open for this particular inspector school to question all these things by referring to a judgment of some other cases which is no, because there is a overage, there is a, I don't know what are the effect of that case. So how could it be applicable to me? And he wants to reopen everything now. My response is, can he do this? And moreover, on trend, you have given me this scale. Only thing now I became a trend from 2014 mellow, and we are in 2024. He is not getting anything.
Yes, Mr. Patak, this part which he says that in the face of the above two judgments, the judgment of the State Education Tribunal while order dated so and so in J case number so and so, taking into consideration the ratio of Vivekananda Das for allowing this petitioner unpaid scale of pay by approving his appointment is not just and proper.
My limited prayer mail in this case.
How can he say that?
Kindly come to the prayer mail.
No, I will go. But can he say that? When a tribunal has passed an order, it was challenged by the state in an FAO. FAO has been dismissed and there has been no further appeal. So it becomes final and binding. But I'll go to the prayer. That's it, doesn't matter.
Well, my case is that matter. My point of argument is that matter. Here in this case, that the petitioner prays for. Why I am emphasizing upon that annexure 1 and 2. The petitioner only prays for the backwards area salary. When he is not in a position to establish his case that he is to be treated as an employee with effect from 1/1/2004. Because on the basis of this annexure 1 and 2, he is to get everything matter from the date of his joinings.
No, but he was, it was as if it never existed. There was a order where he is said to be deemed to be in service or something like that.
Well, he are not impugned this annexure 1 and 2.
Respect to these are the extempo argument of my friend and his innovative idea. I don't think this is anything has been spelled out in the counter. Counter is in different way. His argument is different way. Let him file a petition so that I can file a reply to his statements, my friend's statement, as well as to the counter. Because if he will submit something beyond the counter.
My lord, what I am making a submission, my lord, on the basis of the documents, what it is available before your lordship, saying that, my lord, this annexure 1 is a document which is complying the order, said to be the compliance of the order of the honorable courts, my lord. And that is my annexure to the counter, my lord, the last annexure is the joining report in compliance to this particular annexure 1, annexure I, my lord. He has not disputed that and he has accepted that. And whatever the terms and conditions of his service is to be guided, my lord. Now it is to be guided in terms of annexure 1 and 2, what he has accepted. Now, without challenging any conditions, whatever it is available in annexure 1 and 2, he is making a claim that I should be paid with the area of salary of that particular period from 2004 to 2010. But my submission, my lord, once this annexure 1 and 2 are in vogue and they have not been challenged, then in that case, my lord, with respect to the prayer, that area of salary is to be paid from 2004. Well, that cannot be entered.
Well, we'll continue next week again. I'll call for that file, the other file.
Yes,
your application number that arguments in part is this matter
867 of 2007.
I'm fixing a date.
867 of 2007. FAO 6 of 2007. FAO 6 of 2007.
April. 30th April. How? In part is this matter on 30th April along with such and such.
30th April, my lord.
30th April. How many?
I don't know, 15.
15?
In this case, before proceeding with this case, though state is not a party man, but there was a direction to the state to obtain instruction.
By order dated?
But it is order dated.
Last order perhaps.
19/3/2024, my lord.
Yeah, because the university acted upon some instructions said to have been obtained from government as per letter enclosed as annexure L/1. Issue with the government department, let a copy it to me. Oh, that the agriculture department. Yes, you have obtained instruction.
We have obtained the instructions. May I be perfect?
What is L/1, by the way?
L/1.
Additional
counter affidavit 1, 2, 3 and 5.
L/1 is an additional affidavit that letter they have relied on. Next, L/1 is the affidavit, along with the affidavit, it is filed by OUAT. Pursuant to direction of this son.
Who is appealing for the university?
I'm appealing for university.
As it appears, Mr. Rai, you were appointed, you were a SC candidate. In the select list for candidates, for SC candidates, you secured much less marks than the last person in that category. You were appointed somehow under the ST category.
My lord, under what circumstances it's not a fact that.
No, listen. Then I will. So, when the matter came up for promotion to the next higher grade, there was a need to recast the gradation list. But ultimately, the matter went to the law department and everything.
No, my lord. Thereafter, my lord, he didn't object to that one. Thereafter, he availed one promotion.
Yes, that one promotion was also availed.
Then, after getting promotion,
Only 3 lines,
Hence, Sri Mandal has so far already, I think you give a copy to them. It will be better. So that Mr. I will be in a better position to reply. Yes, what is the Mr. Pata? Both Mr. Rai and Mr. Panda, both we can assist the court.
My lord, the original I have a photocopy with me. The original may be kept in.
Yes,
I will provide them the.
Yes, as directed, Leonard AG has obtained written instructions from the Department of Agriculture and Farmers Empowerment in the shape of a letter dated 4/4/2024 of the OSD from Additional Secretary addressed to him. Stop. The letter be kept on record. Let copies of this letter be served upon counsel appearing for the other side to enable them to make their submissions thereon. Lest this matter, 7th May. Correct. 7th May.
One of the prayer has already become infructuous. One of the prayer he has made in the petition to give him promotion. So now he has already been retired in the due course of time. So that prayer at least has already become infructuous. We will drop it on that day.
Yes, sir. Item 23.
Item 23.
Item 23. None appears disposed of. Yes. RSA dita to no ba RSA after recess. After recess. ये जो आओ कितना अच्छी आओ कितना ये चल रहा है सर आओ मॉडिफिकेशन कितना अच्छी मॉडिफिकेशन सर नो सर मॉडिफिकेशन सर
Item number 36 Mela. In this case, for extension of income bill of the present petition Mela, due to illness of her mother Mela, suffering from cardiac problem Mela. The illegal so
the next one
instruction regarding the
ST and hypertension.
He has granted last order can see the my lord.
For the first time.
Also,
1 month granted. Earlier was granted an interim bail.
Yes,
he wants extension for the first time.
Yes,
it is submitted that the condition of the petitioner's mother has not improved and that she is still under treatment. So, considering the submissions as above, the interim bail granted by order dated 13/3/2024 is further extended by a period of 1 month.
Well, paper in course of that Friday is the last day. Friday ହଉଛି surrender.
ଆଉ ମୁଁ ତ ଓହ୍ଲାଏ ସେ ଟାଇପ କରୁନି ତାପରେ ମୁଁ
Friday surrender କରିବୁ ତ.
ବ୍ୟସ୍ତ କାହିଁ ହଉଛ? Yes.
37 is your lordship.
Yes.
I am there virtually.
What do you want in this case?
Lord, I have prayed for interim bail on the ground of an operation being required. The last time instructions were sought for. I believe the state has obtained instructions.
Yes, madam, I have obtained instruction, but patient is denying for operation.
No, they brought me immediately to SCB and without my family or anybody there, they said that an operation is to be made.
Petitioner is last page, perhaps. Surgery is required. He has asked for, but
he says that he is not willing for surgery.
He said that immediately without anybody being informed, it could not be done.
No, sir. When in this medical document, when the doctor himself writes that he is not willing for surgery, how can I assume that because of these conditions he refused?
Yes, I am submitting one thing, your lordship.
Launch ପରେ ଦେଖିବା. Launch ପରେ ଦେଖିବା.
Next week as well.
Appearing for the informant.
I say pass over. Pass over.
Next week as well.
Next week. All right, next week. Next week.
Item 38.
38, lordship directed to surrender within 2 weeks. Due to mistake of father's name, time has already been.
Further time is allowed to the petitioner to surrender.
Milo.
And C.
B and similar.
So what are the facts? LCR is there? Is the LCR available? Yes. Sorry. LCR नहीं. कितना?
LCR पर नहीं.
LCR भी कॉल लिखे जी. What is the office note?
And any dual or semi fixed similar, it can be disposed of.
No, I just want to see if the LCR is there today. We can have here.
ପିଲା ମଗେଇ ଦେଇକି ସର୍ଟ ଡେଟ୍ ଦେଇଦେଲେ ମଗେଇ ଦେଇକି ସର୍ଟ ଡେଟ୍ ଦେଇଦେଲେ ହବ ନହେଲେ ଯଦି ନାହିଁ
The LCR was called for by order dated 9/1/2019. The same is not in record. The court below be reminded to transmit the LCR without any further delay so as to reach this court by what date karo the week 30th April. Place this matter on 7th May. Week commencing 6th May. This order be communicated to the court below forthwith. Let the LCR come.
There is another related to this. There was a WPC 10,795/2008 was being disposed. It is same matter. That may be.
All right. This is the matter on 7th May along with WPC number
10,755 of 2008.
10,755 of 2008.
Yes.
That is a disposed of case for reference. My minutes.
The same thing related to this one. Obligation.
Item 35.
What is this, Mr. Mishra? Fresh matter. What? Fresh matter?
Yes, ma'am.
Not been admitted.
Not been admitted.
What is the matter about?
The matter is that my father has filed this suit.
Confirming or reversing?
Reversing.
Reversing.
My father has filed this suit for a declaration of occupancy right and permanent injunction.
Banamar Mahapatra.
Banamar Mahapatra.
Yes.
He has filed this suit on the plea that one ex-intermediary Mirza Tahir Beg, who was the ex-intermediary having 17 acres, 31 decimals. There was a partition between the relatives of that intermediaries. In the year 1939, 20th 9, 1939, a lease has been executed in my favor. I means my father's favor for an extent of 8 decimals, 8 acres.
Lease executed by whom?
A lease executed by Mirza Tahir Beg. Out of 2 plots, one is 142, that is 6 acres, 145, that is 2 acres. By virtue of that lease deed, it is an unvested lease deed. I am in possession of the same. In the year 1998, government has, though it is vested in the year 1963, settlement ROR has been prepared in the year 1963, but government has leased out 2 acres each to 3 persons, that is 6 acres from the said land.
So it vested in the government?
When the vested in the government.
Yes. What happened to your lease at the time of vesting?
My lease.
Your lease was executed prior to vesting?
Prior to the vesting, in the year 1939.
39, right.
Vested in the year as it shows 1963. And the settlement ROR was prepared in the year 1998.
1998?
Sorry, 1963. I'm sorry. In the year 1998, government has leased 3 plots. I mean 2 acres, 2 acres, 2 acres to 3 different persons. Out of that 14 acres, 21 decimals. Then balance is 8 acre is in my possession. When the RI has instituted an encroachment proceeding in the year 1998, my father filed a suit for occupancy right as well as permanent injunction.
What was the extent of lease granted to you?
8 acres.
That 8 acres.
That 8 acres.
That 8 acres, which was under your possession, you filed a suit for occupancy right.
Occupancy right.
Yes.
The defendants, like the state, so also the private defendant, those who are the leaseholders, they have appeared.
They are the leaseholders of the other, that 2 acre each.
The government has leased separate plots.
So how are they affected?
Because they try to encroach the entire land. I mean, it is a government land, my lord, as per the state government's issues. And it was recorded in the Abadojogya Anabadi. That's why they want to encroach, because there is no dimension of their lease.
Okay, okay.
And state has appeared. State says that when it is vested to the state, free from all encumbrances, and there is no Ekpadya and Jamamandi, and no tenancy ledger, it cannot be said as the lease has been executed. One thing. Second, lease has not been registered. Third, when I got the land of a Jama lease, because being an army personnel, just adjacent to the my lease area, and I'm not entitled to get that same. Accordingly, still the Land and Trial Court declared the suit in my favor. Taking the evidence of the boundary tenants, those who have categorically stated I am more than 12 years, because your lordship knows that section 23 of the OT Act, 12 years is mandatory. And the person who collected the rent, even after vesting also, and keeping the subsection 1 of section 8 of the OEA Act, as it is being vested, I was as a tenant or a royal, I will be a royal after also vesting. And keeping the Land and Trial Code also emphasize the section 23 and 24. These 2 ingredients has been satisfied, declared the suit in my favor. State preferred appeal, so also the other lessees, they have preferred the appeal. I have preferred 2 appeal. One is 441, other is 442. So far, the London First Appellate Court held that a lease must be registered. But the language of section 23 says registered or otherwise.
and judgment of our own High Court 1962 onwards that oral lease is permissible in case of that section 23. But the London First Appellate Court says there is no ekpadia or tenancy ledger has been shown.
You could not prove the execution of lease. That is
Yes.
according to the.
Yes. And second point hold that sections 117 of TP Act has for the agricultural purpose. Your Lordship, if a lease is to be registered on section 105 or 10, then the consequence will follow to up to the 117. If his lease is an optional under section 23, then section 117 has no role at all. Here the plaintiff, my father has pleaded for the purpose of agriculture and horticulture. If I be declared as first royal, then section 117 will be taken into account. Unless I will satisfy the ingredients of section 23, read with section 24 of the OT Act, then I have no case at all. The London First Appellate Court says that unless a lease is registered, which is not provided otherwise in the OT Act, hence I have no case. Then second view is that during pendency of the first appeal, the London Trial Court exhibited London Appellate Court exhibited certain documents.
Additional evidence.
Additional evidence. That additional evidence, I have exhibited one partition deed of the year 1934 because by virtue of the partition deed, the lease has been executed in my favor. And the defendant, the state has exhibited B, W and Y, 3 documents. One is Sabik Pata and letter. The Sabik Pata shows which I have to be exhibited, that is Mirza Tahir Beg. If that's so.
Anything mentioned in the remarks column?
Pardon?
Anything mentioned in the remarks column?
That has not been discussed by the London First Appellate Court.
Now, what is your case? Is anything mentioned actually in your?
No.
Showing
My case is that by virtue of the partition.
And is there any note of possession?
No. There is no note of possession. There is nothing has been.
So the ROR stands in the name of the ex-executive. All right.
Because vested in the 63, it was recorded as our.
So there are 2 things. First is there is no note of possession. There is no ekpadia. There is no tenancy ledger.
No tenancy ledger. As per the, because there is no tenancy ledger.
Except for that document, you have
exhibited upon rent receipts collected by the ex-intermediaries. The language of section 23 and moreover, if a lease has been executed, let us a lease, unregistered lease has been executed, and I am in possession. Then the question is under section 238 of the OT Act, the government is to come forward to challenge that or not to challenge that. Here 23 says definition of settled right. Every person who for a period of 12 years, whether wholly or partly, before or after the commencement of that, has continuously held as a royal land situated in any village, whether under a lease or otherwise, shall be deemed to have become on expiration of that period a settled right in that village. If this subsection 1 read with section 24, then this language is that every person who settled right of a village within the meaning of section 23 shall have a right of occupancy in all land for the time being held by him as a royal in that village. These 2 provision has been taken in note by the London Trial Court. Read with section 8 of the OA Act, because your lordship knows if a person is a tenant prior to vesting, will be treated as a tenant after vesting under the state and under the ex-intermediaries. Here, if it is that so, the London First Appellate Court does not touch the provisions or the findings given on the OA Act itself, and held that this suit is not maintainable. And the London First Appellate Court also held, in case of that Harapriya Vishoy case 107, the lease must to be registered. But when it is an OA Act, I want to settle the land in my favor, then my lord 6-7 is there. It is admitted position law in Vrindavan Sharma case, Harapriya Vishoy case, the lease is to be registered. But here I want a settled right. of the occupancy right only, where the title cannot be decided. In 6(7), the title has to be decided. The learned First Appellate Court, Your Lordship, has kindly see the evidence also noted in running page 20, internal page 23. Exhibit 3 clearly proves that plaintiff is in continuous possession of the suit's property as a tenant for more than 12 years.
All right. We'll admit it.
And I have only framed 2 questions.
No, you have framed in your appeal memo, you have framed 4 or 5 questions. Out of which I think
only question number A and B.
Let me see. That will cover, I think.
My lord.
So the section 22 and 23 of the Odisha category stated that if a person is Sri P.K. Mishra, Learned Counsel for the Appellant, peruse the judgment passed by the lower appellate court, considering the submissions and the grounds raised. Admit. The second appeal is admitted on the following substantial questions of law. A and B lekho kinte B re tike change ho. B re lekho one ta jaha chi lekhi devo. It is slightly, it could have been better worded. Over section 22 and 23 of that. Whether a person residing prior to 12 years, wholly or partly, before and after commencement of the Odisha Tenancy Act, can be termed a settled rayat in view of the provisions under section 22 and 23 of the said act. Second, lekhantu. Whether a lease deed is mandatory, he is required to be registered mandatorily for a declaration of occupancy right under section 24 of the Odisha Tenancy Act, and whether acceptance of rent or oral agreement can prove creation of tenancy. All right? These two call for the LCR. Let's this matter on
We commencing 6th May. We commencing
6th May. Issue notice to the respondents by registered post with AD. Who are the respondents?
Here, my lord, there is 2 appeal. With the state and others, in both the cases, there is a state and others.
No, others are there. Others you have to take notice on them. On state also, you have to take notice, or you have to serve copy.
Extra.
Issue notice. Let an extra copy of the appeal memo be served upon the State Council within 3 working days. Issue notice to opposite party numbers 228 by registered post, making it returnable within 4 weeks. Requisites be filed within 3 working days. Place this matter on the week commencing
13th May.
13th May. 13th May 4 weeks be
I filed an interim application.
What interim application?
For injunction, but my lord status quo as on date as
Status quo with regard to the suit property shall be maintained. Status quo as on date with regard to the suit property shall be maintained till the next date. Well, you said two appeals. There is only one appeal has come.
Two appeals, I have mentioned two appeals before.
ଗୋଟାକେ ହେଇଛି ଆରଟା ଆସିନି।
ଆରଟା ଆସିନି, ସେଟା 442/23
ସେଟା କାଲିକି ନେଇ ଆସିବା। ସେମ୍ ଅର୍ଡର ହେଇଯିବ।
ପରଦିନ।
ଆରଟା ନେଇ ଆସିବ ପରଦିନ ହେଲା 442 ଟା।
ସାର୍।
I've been called upon to hear civil matters after a long time. With experts like Mr. Mishra and Mr. Das here, one feels difficult.
One can claim to be an expert.
That is true. That is true.
Okay, list item number 31.
Item 31, pass over.
Item number 32.
That's what you.
341, 374, Due to this previous dispute, the petitioner along with others asserted the informant by means of a crowbar and
First or second order?
First parity is there.
Same order.
Item number 33.
Pass over.
Item number 34.
May I please announce? Matter 307. Injured has sustained grievous injury or his leg was fractured. And the co-accused has been released from bail. Vital part of 90. Vital part of the body in 90. Leg recalias.
Same order कर दियो तादेरे last line of paragraph 5 टा काट दो paragraph 6 टा भी कर दो है ना से एमिति इंग्लिश लिखितले जे हम बुझी पालुनी से तुम से डायरेक्शन दी थी से नॉलेज थिबा दरकार ना
Item 35.
if a co-accused murder has granted bail, the basing upon the statement of the co-accused present.
Some adult elephant causing its death. Same order? Pilot. Same order.
Item 35.
Item
35. 36.
That's all.
Item 37.
35, 6.
Here the petitioner, the mother-in-law and father-in-law, my lord. Charge sheet has been submitted, my lord. And only prayer, my lord, I pray. Meantime, husband has been granted.
Wait. Item 36.
Yes, my lord.
Susoma Pahanta Singh.
Yes, my lord. Charge sheet has been 498, 306, 304B and 34 of IPC. Charge sheet was submitted. In meantime, the main accused husband has been granted bail by the Honored Trial by this Honorable Court, my lord. I will
3 SCST Act?
No, my lord. 498, 306, 304B, 34 of IPC.
Earlier, they have filed
Yes, my lord.
302 is there.
No,
306 is there.
Yes, my lord.
So,
4B. I pray only, my lord. The husband has been granted bail by this Honorable Court.
what is it?
first or second parity. Yes.
The petitioner apprehends arrest in connection with such case. The petitioner is the mother-in-law.
Mother-in-law,
father. The petitioners are the mother-in-law and father-in-law of the deceased, who is said to have been subjected to physical and mental cruelty and ultimately put to death. It is submitted that the husband of the deceased, who is the main accused, has in the meantime been released on bail by as per order passed by this court in bail appeal number 146255 of 2023. Considering the submissions as above, first or second?
Parity.
Parity.
Item 37.
Might please also. Lordship, item 37, on the last occasion, as Lordship has directed in the other co-accused bail application, that this matter along with the other co-accused bail application to come together. But today only one of this case has been listed. Lordship may put this matter in any other day along with the other co-accused bail application.
And is this matter in the week commencing 22nd April along with?
ABL appeal number 13305 of 23.
13305.
Appearing for the information. Grateful.
Much obliged.
Item 38, urgent bail application.
Pass over.
Item 39.
Lordship, the petitioner is in custody since 21/3/2020, more than 4 years and above. Out of 45 charge sheeted witnesses, only 21 witnesses are examined. And I supply the.
As directed, the
And
court below has submitted a report stating that out of 45 charge sheeted witnesses, 21 have been examined
Lordship.
and 23 remain to be examined, with 2 being declined. Yes, what is this case?
Offense under section 341, 323, 302 of IPC, read with section 25, 27 of Arms Act.
You have the case diary?
No, that case diary is not there. We have just now supplied the copies of the depositions.
So unless he goes through the case diary and these depositions, how can he?
That's right.
You're given a copy, huh?
Just now.
So let it come next week then. Next week you obtain the case diary also.
Next week, 29th.
All right. List this. Learned counsel for the petitioner files copies of the depositions of the witnesses examined so far. The Learned State Council requests for some time to produce the case diary. List this matter in the week commencing 29th April.
Item 40.
Please, I beg pardon, Your Lordship, in item 37, interim order may be continued.
I follow. 37 interim order to continue.
Much obliged.
May I please, Your Lordship?
Item 40.
Yes.
On the application order 439 minors and the allegation 302 minors. And the accused are custody since minor 14/7/2022 minors. The fact of the
you have the case diary?
Case diary is there, madam.
All right.
Well, the fact of the case like this minors on 12/7/2022, the deceased and the son-in-law, when they're going to the agriculture field to sow pesticide, they had a quarrel between them. Then this incident took place. Thereafter, he narrated the entire story. His brother-in-law, he lost the FIR minors. So in the meantime, minors, almost all the witnesses examined minors. Absolutely, there is no allegation against me.
Especially when
you are Hemanta Bhoi and how many petitioners?
2 petitioners.
Hemanta Bhoi and Shashi Bhushan Bag.
Shashi Bhushan Bag. Third one is juvenile bail.
Who are the main witnesses?
One Jitmal Bhagati, that brother-in-law who was accompanied with the deceased to the cultivated land.
Jitmal Bhagati has been examined?
Yes, my lord.
PW1.
PW1 is Jhanana Bhagati.
Sorry, ma'am. PW4.
Yeah, PW4, the informant Sravanpur is my brother. But he has implicated you.
Yes, Lord.
He directly implicated. I immediately saw that these 3 accused persons were chasing the deceased. I saw the accused Tia alias Hemanta Bhoi were holding a bhujali and assaulted the deceased on his throat, chest, belly, and back by means of a bhujali. He directly said.
And that knife also recovered from the.
I rushed to the spot and found what more could he have said? Yes, Mr. Tripathi.
Yes, my lord.
Direct evidence.
Since long they are in the custody minors and
And
In case of murder.
29th is a date, my lord, for the IO examination, my lord. So at least that be considered, my lord.
What consider? Like, serious case. If you can make out a case for interim bail, one can consider. But this is on the face of this direct evidence, that it's पूरा एकदम कोई चीज जैसे गोड़ेले तक मारिले, भुजाली रे मारिले, ये जगह मारले, ये जगह मारले, ये जगह मारले.
In that case, my lord, they have seized one Bujali, my lords.
No, he has also said about He says about petitioner number 1.
Yes, my lord. So
one may say,
who may be released, my lord?
No, how? Who was a part of the gang?
Yes, my lord.
Which says, you look, on the way near there was a culvert where the above 3 accused persons, Tia alias Hemanto Bhui, Bagho alias Sashikanta Mishra, petition number 2 is Bagho, and Assis Bora Sagar. Assis, that is CCL.
He is a juvenile.
He is a CCL, yes.
Yes, ma'am.
And I heard that this is how to Morili, I saw Samantha Tinjan never chased coach and Hemanto Bhui, the Bujal.
Well, while changing, my lord, is it believable that they can cut his throat, my lord? If the person is changing, my lord. The changing normally it's backside, my lord. It's changing and they're running. So is it possible, my lord, to cut the throat while changing a person, my lord?
So that's a trial. Prima facie evidence is there. How about it? No. Long period of detention, yes, I admit, but this is a case where there is prima facie evidence, strong prima facie case.
8 external injury, stab and all.
Stab part is koi Stab part
incise aberration, stab 1, 2, 3.
Incise,
4,
maybe the
2 incise, 4 stab and 2 aberration.
How about it? Yes. The petitioners are in custody in connection with such and such case. It is alleged that both the petitioners and another person, who is a CCL, quarreled with the deceased while he was going to the agricultural field to sow fertilizers, to apply fertilizers. Learned counsel for the petitioner submits that the petitioners are innocent and the case projected by the prosecution is not believable. Learned State Counsel has, however, submits that the materials in the court, including the evidence, clearly shows the involvement of the petitioners in the alleged occurrence. Stop. From the certified copy of the depositions of the witnesses examined so far, produced by learned counsel of the petitioner, this court finds that one of the eyewitnesses has directly implicated the petitioners. Stop. Having regard to the evidence as above, which reveals a strong prima facie case against the petitioners, I am not inclined to allow the prayer for bail. The bail application is therefore rejected. Yes.
Item 41.
May I please, your lordship?
Please, your lordship. Sir, I am a file कराई 122 रुपए 2024 sir. For marriage by interim bail sir.
In which case, sir? Which is your item?
41 sir.
Item 41.
No.
Item 41 is yours.
No. Item 7 will specifically adjourned today for OPID matters. Yesterday.
Which one?
Item 7 weekly list. Specifically adjourned
matter 2 p.m. lordship.
2 p.m. lordship.
Yes, 2 p.m. रोज 2 p.m. 2:30 को गया अपना. Item 41, yes. जाओ.
Sir, हमरो below IA 172 2024 फाइल कराई sir interim bail पाई. आप kindly allow कर दो से marriage consent पे सब agree होछ sir हम समझ. फादर मदर समस्त एग्री होछ विक्टिम मध्ये तो कंसल्ट सी मध्ये एग्री होछन सर तांगे
कोन एग्री होछन तेगे
मैरिज पाई सर
मैरिज में
इंटरिम
376 2 कोन अछि देखे
victim was also pregnant victim was examined or not that
has the victim been examined?
2022 my lords. It's a case it was registered under section 307 but subsequently
turned to 302
my lord.
You have the case ready?
My lord,
yes.
There is a case, my lord. There is no previous dispute is there, my lord. Due to sudden provocation, the petitioner has assaulted the informant. Petitioner is a, my lord, vegetable shopkeeper, my lord. And there on the relevant date, my lord, there was a hot word exchange between the victim and the petitioner for rate of the vegetable. And due to sudden provocation, he has assaulted to the neck of the victim, my lord. Subsequently, he fell down there and taken to hospital. And
You have given the depositions of witnesses. Anybody has stated anything?
My lord, I am submitting. Meantime, my lord, the complaint has also be.
Who is the eyewitness?
Eyewitnesses Sanjay, Subra, and Padmacharan sir. They are not at exam.
My lord, the Govinda, one of the eyewitness, my lord, and the complaint, the Sashikanta Pradhan, the complaint. He had also been, my lord, hostile, my lord. Meantime, not supported the prosecution case. I have marked it.
Who are the eyewitnesses?
My lord, one Sanjay Kumar Pradhan.
Sanjay Pradhan has been examined.
My lord, Govinda, my lord.
Yes, Sanjay Pradhan examined. Sir,
Kumar Sahu.
Subrat Sahu?
No.
How pending Sahu?
Govinda, complaint has been hostile.
The complainant is he an eyewitness?
No, my lord.
Sashikanta Pradhan? Wala. How many witnesses have been examined so far?
And out of 31 witnesses, 11 witnesses have been examined.
So let those two be examined. We'll keep it pending.
Yes, ma'am.
We'll keep it pending. Huh? Election matter will be commencing 13th May. Learned counsel for the petitioner shall produce copies of depositions of the witnesses examined in the meantime. Yes.
Good.
Item 44.
Under custody since 12/4/2022. Offense under section 302, my lord. Date of affair is 12/4/2022. Same day is taken to custody. Allegation in the affair, my lord, that while the deceased was taking after his meal were taking rest, the petitioner assaulted him. Due to a land dispute, there was a quarrel between the parties.
Yes.
My lord, head injury, head and leg injury, intracranial hemorrhage. That is the PM report. And leading to discovery, my lord, that trachea was seized from the present petitioner. Eyewitness, my lord, with the wife of the deceased. She has stated. ମୋ ସ୍ୱାମୀ ଖାଇସାରି ଘରେ ଶୋଇଥିଲେ ଏଇ ସମୟରେ ଘରର ଦାଣ୍ଡ ପଟୁ ପାଟି ଶୁଭିଲା ଓ ହଠାତ୍ ଆମ କବାଟ ଟିକେ ଜୋରରେ ବାଡେଇଲା ମୁଁ ଯାଇ ଝରକାରେ ଦେଖିଲା ବେଳକୁ ମୋ ପୁତୁରା ମିଲ୍ଟନ ଦିଗାଲ ହାତରେ ଗୋଟେ ଟାଙ୍ଗିଆ ଧରି କବାଟ ବାଡଉଛି ବାହାରେ ଥିବା ଗୋଟେ ଆଇନାକୁ ମଧ୍ୟ ଭାଙ୍ଗି ଦେଇଛି ହଠାତ୍ ଆମ କବାଟ ଖୋଲିବାରୁ ସେ ଭିତରକୁ ପଶି ଖରାରସରେ ଗାଳି କଲା ଓ ଜିନିଷପତ୍ର ଫପଡା ଫପଡି କଲା ମୋର ସ୍ୱାମୀ କଣ ହୋଇଛି ବୋଲି ବାହାରକୁ ଚାଲ କହି ସେ ଆଗେ ବାହାରକୁ ଗଲେ ପଛରେ ମିଲ୍ଟନ ଦିଗାଲ ଯିଏକି ମୋର ପୁତୁରା ତାଙ୍କ ପଛରେ ଧରି ଆସିଥିବା ଟାଙ୍ଗିଆରେ ମୁହଁକୁ ଗୋଟେ ଚୋଟ ପକେଇଲା ଓ ଦୌଡ଼ିକି ଜଙ୍ଗଲ ଆଡକୁ ଚାଲିଗଲା ମୋର ସ୍ୱାମୀ ତଳେ ପଡିଗଲେ ଓ ତାଙ୍କ ମୁହଁରୁ ପ୍ରବଳ ରକ୍ତ ବାହାରିଲା ମୁଁ ବାହାରକୁ ଆସି ପାଟି କରିବାରେ ମୋର ସମ୍ପର୍କୀୟ ଗାଁର ଭାଇମାନେ ଆସି ମୋର ସ୍ୱାମୀକୁ ଅଟୋ ସାହାଯ୍ୟରେ ରାଇକିଆ ହସ୍ପିଟାଲକୁ ନେଲେ and that Tangia was seized from the present petition.
The letter will be examined.
Examined. Already examined.
Hostile.
Partly.
Partly hostile, man.
Empty the contract.
The na kaun?
Runuma Digal.
Runuma Digal.
कौन हो कौन हो
रोजानी 12/4/2022
जीवन साहब आयो सावन
it's an interim bill no
interim bill you make out a case for interim bill in the face of direct evidence
well see actually SKDB is conducting this case
yes
yeah see now
well
item 45 I will take your looks the petitioner
you inform Mr. Bhuya
I am here.
Oh, you are there.
The petitioner is in custody since 22nd June 23. The case has been lodged after 17 days of.
You are the husband?
My lord. The other co-accused persons have released on bail
And the petitioner.
307 or 3, it converted to 302.
No, 302, 307.
You have the report?
He has given that acid,
Toilet acid.
toilet acid, he was
Yes.
something to take for toilet acid.
Yes.
Lordship directed me to take instruction regarding for health condition.
Bathroom cleaning acid. ଦେଖନ୍ତୁ, the word CHINNING appearing in paragraph 3 of order dated 3/4/2024 be corrected as cleaning, CLEANING. है ना? She was treated initially at Buguda, then at Barampur, and then at Cuttack.
My lord.
I did not find any documents, that's why I had asked you to obtain. If somebody has been administered acid, naturally very serious injuries would have occurred. Let us see.
He was obtained in the month of February. Then last one is the recent.
Yes. The medical reports clearly support the prosecution allegation.
My lord, charge sheet has been submitted. The petitioner has no such criminal antecedents. He is in custody more than 7 months. So after 17 days, the petitioner has informed his family members or family.
No, what is your specific case that the allegation is false?
No, my lord. She tried to commit suicide.
Well, how do you say that? On what basis are you saying that? So you are the husband, so there must be some reason why you must be aware of the reason why she wanted to commit suicide.
The external affairs. From the day of marriage, they have no such relationship like husband and wife.
So she herself drank the bathroom cleaning acid, according to you.
I have not given, my lord. She has taken.
Any evidence of
161 of the
she coiled you when the husband came drunk and started beating and doing all sorts of nonsense, and she threatened to commit suicide. You handed over that bottle, saying that pee de. She pee dela.
Lordship, any stringent condition.
Ekdam stringent condition hela je rejection of. That is the only condition. The petitioner is in custody in connection with such and such case. It is alleged that the petitioner, being the husband of the deceased, subjected her to physical and mental cruelty, demanding further dowry, being assisted by his family members. On the date of occurrence, on the night before the occurrence, he came home in an intoxicated condition and quarreled with the deceased. On the next day, again, when there was a quarrel, the deceased threatened to commit suicide, whereupon the petitioner is said to have handed her a bottle of bathroom cleaning acid, which she drank. Stop. This prima facie shows a case of instigation. Under such circumstances, I am not inclined to allow the prayer for bail, which is therefore rejected.
Liberty to renew.
It shall be open to the petitioner to renew his prayer after examination of Renuka Pradhan. कौन था ना? Renuka Pradhan बोले. निकली? हाँ? No, statement एक नंबर पढ़ेगी. Renuka Pradhan, yes.
Item 46.
Is it like for next week? We have to risk it.
Well, next week is before.
Item 47.
Chada.
Item 48.
Item 47, I am from the information.
48.
47.
But petitioner is not there. I have passed it over. Let us speak. Yes, Mr. Mishra.
Yes, may I please? This is a case under section 420, 468, 471, 471, 120B and section 6 of OPID Act. In the present case, my lord, they have been remanded in this case, my lord. They have arrested in UW case number 14 of 2022, my lord. Good. Copy the eyes, na?
Copy again.
हाँ,
your name appears. Mr. Bhuyan. Probably you have missed the list.
ये भी दिया है.
If you are not ready, we can take it up. That's for tomorrow.
Lordship, in the previous case, my lord, in the main case, my lord, your lordship granted interim bail for a period of 4 months, my lord.
I will consider that. I will consider that. I will consider that. After tomorrow, let it. He is not ready. So. Then both sides be ready. Pass over.
Item 49.
Mr. Bhuyan, please go through that.
49, may I please, my lords. My lords, on the last occasion, the lordship wanted to know whether PW3, the last witness, has been examined or not.
Out of 3, 2 have been examined. 1 witness was to examine the last date of hearing. That is author's thing. Wants to take instruction. Yes.
My lords, have obtained instruction. It has been fixed to 20th, my lords, for appearance. Notice how taku, kintu he is not appearing.
20 तारीख को.
आज्ञा.
20 is 20 तारीख को. 20 तारीख तो शनिवार. हाँ, शनिवार होगा नहीं. For which court is this matter?
My lords, before
special judge from district judge. Then Saturday there will be no court. District judge doesn't have a court on Saturday. So you are wrongly informed. You are wrongly informed, sir. 20th ही नहीं थी वो. 22 को नहीं थी वो.
Let's say 22 ही थे.
ही थी वो कौन ही थी वो?
My lords, कोडिये, my lords. My lords, कोडिये.
Korea है ना थी भाई. My lords. It is before the sessions court. My lords. Sessions court doesn't function on Saturday.
My lords. That's rule information.
Rule information. Place this matter in the week commencing 22nd April. Next week, Learned Council, the previous order be complied. Yes.
Item 50.
Item 50, I am supplying the deposition copy to the State Council.
It's a 302 matter.
Yes,
Somebody do 302. You are the husband.
Yes, my dear.
All right.
So that's why I am bringing deposition copy to Delhi next.
Probably against you, isn't it, Mr. Sahu? Yes. Your demeanor suggests so. Learned Council to the petitioner.
Another thing about the eyewitnesses were examined or not? That was
Eyewitness examination. ସେମାନେ ସେମିତି କିଛି eyewitness କେହି ନଥିଲେ ସେଥିରେ ଖାଲି.
All right. You have the case data. We'll see. You verify it
next week.
List this matter next week. That's all.
Item note 7.
I think I think Mr. Bhuya was to give a reply. You had given already a reply.
I have already.
Along with this matter. We'll see. Let us hear. All right, let us see. He will come again.
Again. Pojant kali ashiba, kali siye ashibe, mu ashibeni.
Ajata jiwa. Jai Shri Ram.
I have handed over. Only see 164 statement.
Of Shubhendu Behra. Who is he?
Keshav Chandra Behra.
No, Shubhendu Behra लिखित थी.
दुई नंबर एक नंबर केशव चंद्र बेहरा ମୁଁ ରୋଜଗାର କରିବା ପାଇଁ ସୁରଟରେ କାମ କରୁଥିଲି କିନ୍ତୁ ଲକଡାଉନ ସମୟରେ ଘରକୁ ଫେରି ଆସିଲି ଓ ଚାଷବାସ କଲି ଯେହେତୁ ଚାଷବାସରେ ରୋଜଗାର ଅଟେନି ମୁଁ ଏସଟିଏ ସୋଲାର ଟେକ୍ନୋ ଆଲିଆନ୍ସ ବିଷୟରେ ଶୁଣିବାକୁ ପାଇଲି ଓ ଏସଟିଏ ର ଯିଏକି ଭଦ୍ରକ ଡିଷ୍ଟ୍ରିକ୍ଟ ହେଡ୍ ଥିଲେ ନିରୋଧ ଦାସ ମୋତେ କହିଲେ ଏସଟିଏ ରେ ଇନଭେଷ୍ଟ କରିବା ପାଇଁ ମୋତେ ସେ କରିଥିବା ଘର ଗାଡି ମଧ୍ୟ ଦେଖାଇଲେ ଯାହା ସେ ଏସଟିଏ ରେ ଇନଭେଷ୍ଟ କରିବା ପାଇଁ କରିବା ପରେ ପାଇଲେ ଓ ମୋତେ ଏସଟିଏ ରେ ଇନଭେଷ୍ଟ କରିବା ପାଇଁ ମଧ୍ୟ କହିଲେ ଏହା ବିଷୟରେ ମୋ ସାଙ୍ଗ ମାନଙ୍କ ସହ କଥା ହେଲି ଏବଂ ସେ ମୋତେ ଏସଟିଏ ରେ ଇନଭେଷ୍ଟ କରିବା ପାଇଁ ନିରୋଧ ବାବୁଙ୍କୁ ପ୍ରଲୋଭିତ କରିଲେ ଏବଂ ମୋତେ କହିବା ବାବଦରେ ବାର ଫୋନ ମଧ୍ୟ କଲେ ତାପରେ ଏସଟିଏ ରେ ଇଣ୍ଡିଆ ହେଡ୍ ଗୁରତେଜ ସିଂ ଓ ଆଉ ଜଣେ ଫରେନ୍ ମଧ୍ୟ ଭଦ୍ରକ ଆସିଲେ ଫରେନର ମଧ୍ୟ ଭଦ୍ରକ ଆସିଲେ ଓ ହେଲୋ ହୋଟେଲରେ ରହିଲେ ସେଠାରେ ଆମେମାନେ 2000 ରୁ 3000 ଲୋକ ଯାଇଥିଲୁ କିନ୍ତୁ ସେଦିନ କୌଣସି ମିଟିଂ ହୋଇନଥିଲା ତା ବହୁତ ଦିନ ପରେ ନିରୋଧ ଦାସ କହିବା ମୁତାବକ ଏସଟିଏ ରେ ଲକ୍ଷ ଟଙ୍କା ଇନଭେଷ୍ଟ କଲେ ଏବଂ ତାଙ୍କର ଗୋଟେ ହ୍ୱାଟ୍ସଆପ୍ ଗ୍ରୁପ ଭଦ୍ରକ ଏସଟିଏ ଟାଇଗର ଥିଲା ଯେଉଁଥିରେ ସେ ମୋତେ ଆଡ୍ କରିଥିଲେ ସେଇ ଗ୍ରୁପରେ ସେମାନେ ବିଭିନ୍ନ ମୋଟିଭେସନାଲ ଭିଡିଓ ଦିଅନ୍ତି ଏବଂ ଆମକୁ କମ୍ ପଇସା ଇନଭେଷ୍ଟ କରି ଅଧିକା ରୋଜଗାର କରିବାର ପ୍ରଲୋଭନ ଦେଖାନ୍ତି ଗତ 23/4/2000 ତାରିଖରେ ମୁଁ ଏସଟିଏ ରେ 1 ଲକ୍ଷ ଟଙ୍କା ଇନଭେଷ୍ଟ କରିଥିଲି କିନ୍ତୁ ଏଯାବତ କୌଣସି ପଇସା ପାଇନାହିଁ ମୋତେ ମଧ୍ୟ ହ୍ୱାଟ୍ସଆପ୍ ଗ୍ରୁପରୁ କାଢି ଦେଇଛନ୍ତି ଯେହେତୁ
ଇଏ କଣ ଇନଫର୍ମାଣ୍ଟ
ନାଇଁ he is one of the investor
अच्छा
Miller the informant is allegations copy paste I କୋଉଠି ଅଲଗା ଲାଙ୍ଗୁଏଜ ଅଲଗା ଅଛି କପି ପେଷ୍ଟ ନୁହଁ କି ସାଇକ୍ଲୋ ଷ୍ଟାଇଲ ନୁହଁ so lots of kindly see they have not only implicated the client of my Lord Mr. Kanungo, but also against Gurtej Singh, who is the state country head. And your lordship will see, during investigation it has came to light that so far the client of Mr. Kanungo is concerned, he has received more than 18 crores in his account. And
I am more client.
That is my client.
Anyway, that's
separate.
Senior is appearing, it is always a senior's client. Senior never holds the brief. He is engaged to argue.
Yes.
It is all his brief is senior's brief. So,
Please give us the whole asking.
you also see Keshav Chandra and Ramchandra. The verbatim is different and also their implication is different.
See the modus operandi that they speak about is the same, not similar.
Apparently, your lordship, can you see what my non-point Mr. Kanungo has placed before your lordship? That the crypto as held by the Supreme Court is not illegal. It doesn't say it is illegal. It says that if the Supreme Court held that it is not. Here is a case, my lord, it is not crypto. Crypto, as I have explained to your lordship,
one can open his own platform by going to the website and create own wallet. And nobody in the app will know how much he has invested and how much money he in his wallet is there. Here the reverse is that they are allowing people, they are taking money to their account and nobody knows where it is invested. So it is my submission, it is a pyramid structure only on this scheme. It is not crypto. And even Act, they say that we are the people under the Act. Not the Act have given that it has been declared as illegal by the financial institution, intelligence agency or government of India. So yes, my laundry fund is correct. Crypto till date has not been banned, or by RBI it has not been held as illegal. But nowhere Supreme Court said that the crypto is legal and valid. They say, the Honorable Supreme Court said, since they are paying tax, so it is known to them, the persons investing at their own risk. So they are creating their own wallet. It is unknown to everybody. So they are taking the calculating risk. So it is not per se penalty. But here, we will see these persons allowed others to invest through them, and I have given the pyramid how much each of them is getting from one of the investors. So it is meant to defraud the people because they knew that the pyramid will fall. So that is why it is a Ponzi scheme, Miller. I have given all the documents for.
I will ask you one more question. Why is there a detention necessary? Well, now that the charge sheet has already been submitted.
Miller, Nirod Das or can say that he is a person of this area, Miller. He has the property, some property. But so far Guptage is concerned, Miller. But the entire invested amount is in his account. We are still yet to trace it. Miller, by keeping him in the cell also, he is not cooperating and he has not kept any of the family members within India. Miller. The moment he is released, Miller, like your lordships knows, many persons are abroad. We cannot get hold of them in spite of lookout corner notice, serial corner notice, etc. And last time I have said, Miller, so 6 years back, a particular doing was a missing. Till that nothing has been traced. So this person, he will in the India, Miller, there are 140 crores of people. He will be mingled with them. Least said about the investigation, but nobody in the.
But what remains in the further to be done in investigation?
To which he has collected.
So you have submitted a charge sheet.
We have submitted a charge sheet because within the stipulated period we are bound.
No, that's all right. But,
Miller, yes, we have to.
When was it submitted?
30/11/2023.
30/11/2023. So now almost 6 months have passed. Almost, not 6 months, 5 months.
Miller.
What further investigation has emerged?
The hard disk, etc., where the money has gone, it has not been traced as a.
Has any further evidence material come up against them? Has it surfaced?
Reveals, Miller, the further material has been collected. Miller, further investigation reveals, Miller, whatever the investment has come, Miller, out of that, 96% of the investment is held by these 4 people. So that is the further development that this Guptage, Niro and others, they are holding 96% of the investment.
So do you have the list of depositors or investors who, according to you, were cheated?
Miller, so that Odisha is concerned.
Yes, we are talking of Odisha. We are talking of Odisha.
Yes.
What is the amount? What is the number of people who were?
I have given so far investigation reveals. Miller, we have given total number of people. How much they have invested in that? But till the investigation reveals more than, in Bhadrak only, more than 100 people have invested. Only Bhadrak.
What is the total amount?
Again?
Total amount?
Bhadrak re total amount. आणि बर्तन सुद्धा डिटेल पाहिजे 30 lakhs and एठी आता अकाउंट असते ऑफर
21,000 members
ओडिशार 21,000 मेंबर ता भितर जमा आमे पाइथिलु ना 40 जन डिटेल and आउ 21,000 कर इन्वेस्टिगेशन
Look, you'll have to give the case diary, entire case diary.
Was a very short reply, my lord.
Yes.
That I have given you.
मैंने अब गोटे करके दे दे सुविधा नोट करके दे देबे गोटे नोट कर देबे भलो only the bullet points as I always say. Yes,
We will also give your lordships a note. They themselves admit in the charge sheet that this is a person to platform transaction. No money has, let them show a single rupee which has flowed from a person's account to my account. Nothing. They say in the charge sheet as paragraph 16.13 that after the purchase, they're describing this process of how this Bitcoin is, how this cryptocurrency has been invested in. After purchasing of USTD, one can buy STA tokens from Pancake Swap and LA token site. So when one has to sell the token, one has to first convert the token into USTD and then through P2P trade in Binance. The P2P is person to platform of Binance, my lords. Now, my lords, again, I'll just give you lordships why cryptocurrency arose, my lords. For example, my lords, I'm an entrepreneur in India. I want to do business in US. Now, I want to buy 5 shops as showrooms for my product. Now, buying 5 shops in dollars, my lords, these are all legal tender by different countries. Buying 5 shops, I have to convert Indian rupees into dollars, my lords. That becomes a very rigorous affair, my lords, and it takes a lot of time. So what happened? International commerce developed this currency, which was utilized as a medium of exchange. For example, I'm in India, I say, okay, you take this 100 Bitcoins and give me 5 shop rooms. If it is agreeable to those people who are selling the shop rooms, my lords, it's okay, my lords, there is no illegality. Now, my lords, for example, I want to purchase a flat in, let us say, Delhi. I have 100 crypto coins. Today, my lords, its value will be roughly 10 crores. Flat in Delhi costs me 4 crores. I go to them and I say, you accept Bitcoin. That developer says, no, I don't want Bitcoin. I want hard cash, Indian currency, INR. So I have to convert it into INR. That was being stopped by the RBI by issuing a circular saying that this cannot be exchanged for rupee because of prohibitory measures adopted by us. That was quashed by the Supreme Court saying nothing. You can't do it. This is legal. There is no illegality attached to it. So you have to allow them to convert this into rupee. My lords, to this extent, my lords, there are no crypto exchanges and crypto ATMs. Now, my lords, I am inducing someone, whatever my learned, insofar as my client is concerned, my lords, there is absolutely no allegation. His name is Ratnakar Palle. The other clients, but I am saying as a whole, the concept of crypto, my lords, has been misunderstood. Let them show, if they show that rupee has flowed, this 18 crores I have got as commission from the main STA against my client, it is roughly 1 crore which has come from STA to us as commission.
No, sir, not from this.
So now, my lords, the question that remains is, if the ultimate result is legal, my lords, that is the question I've been raising before your lordship. If the ultimate, my lords, investment avenue is legal, can any illegality be attributed, my lords? That is the question I raised before your lordship.
Correct. Her arguments used judgment reserve.
I'll give your lordship a short note.
Parties may file their note of submissions and memo citations, if any, within a week.
Within a week?
Within a week.
inducement part ସେ 161 statement ଗୁଡାକ ଖାଲି ମୁଁ ପଢୁଛି। I further want to state ଏଇଟା ହେଲା ଶିବ ପ୍ରସାଦ ପଣ୍ଡା ସେ ଯୋଉ 40 ଜଣଙ୍କ ଭିତରେ that seeing the enhancement in the lifestyle of the people in Bhadrak who have invested in STA token, I was allured to invest in the same. He saw the lifestyle of the person and he was allured. So what can I do about it? If he comes to me and says that I want to become a member, others are earning money, then the same is Prafulla Kumar Behra. I further want to state here that seeing the enhancement in the lifestyle of the people in Bhadrak who have invested in STA token, I was allowed to invest in the same. So allurement not by me, allurement by if at all, whether by their own instinct of becoming rich. So what can be done with that? But the same is the similar. Rejection order ମୋ କେସଟାରେ ଟିକେ ଦେଖନ୍ତୁ ସେ କହିଲେ ଯେ କୋଟି ଟଙ୍କା ଯାଇଛି ତ thousands of crores. Rejection order ଦେଖାଇକି further, it reveals from the investigation that huge monetary transaction has been made in the SDBS of accused petition, as well as the bank account of his relative and co-acquaintance Niroj Kumar Das has transferred an amount of 2,86,058 only to the bank account of Gupta Singh. So, to my account, if at all any money has come according to them, it is 2,86,080 only to my account it has come. What is his connection with others? They have to say.
One thing I am sorry for Niraj Kumar Das. The FIR has been registered on the date of 28/7/2023. On that very day, my account has been freezed by the IO. On the very day, my account shows balance 37,000, one account, and another account shows 59,000. They said 15 crores. That the charge sheet shows. That is P2P, person to person transactions, buying, selling, transferring. I am not kept, nor misutilized, misappropriated.
ସେଥିରେ ଅଛି ଯେ ପ୍ରିଭିୟସଲି ଆମେ ହାୟର ରେଟ୍ ପାଉଥିଲୁ ଏବେ କମି ଯାଇଛି ସେୟାର ମାର୍କେଟରେ ଯଦି ଯିଏ ଇନଭେଷ୍ଟ କରୁଛି ସେୟାର ବଢିଲେ ସେ ବେଶୀ ପଇସା ପାଉଛି ସେୟାର କମିଲେ ବୁଡି ଯାଉଛି ତମେ you have taken a calculated risk as the Supreme Court says and all the account and if your lordship knows it is elementary that nowadays every bank account is linked to the KYC, PAN and KYC. So if I have amassed a huge fortune of 11,000 crores or some says, he says thousands of crores. How many thousands I do not know. But if I have amassed, it is a matter to be dealt with by the income tax authorities. Has there been any information given by these people to the income tax authority and what is the income tax department saying in this? So you just can't make an investigation on the basis of presumption and detain people for all times to come. I have given you 3 judgments.
I think it will be better if you give it by way of a citation. So memo could be better. And Mr. Bhuya also.
I would say Supreme Court
ମଝିରେ 143 rupees ହେଇଯାଇଥିଲା ସେତେବେଳେ that time we were all heroes. We were all heroes. ବଢିଆ ଆମକୁ investment କରେଇଛନ୍ତି. Today just because it has dropped balance.
7 rupees for that. All right.
Our wallet
everything for that.
Only the fluctuation is in the
so if the custodial interrogation is no more necessary, why should we detain and all these days I have not asked for custodial interrogation. Even Supreme Court in this case, Ganesh Kumar Sivkumar Sagar says that once you have done with custodial interrogation, no meaning in detaining them.
Yes.
And economic offense until case to आरंभ करी तो समस्त କହିଛନ୍ତି ସେଟା apply କରିବ even to economic offense cases.
এইগুলা সব
Item 51. That's all.
Item number 52.
May I please?
52 and 53.
Yes, Mr. Kanal, saying something?
No, my lords, there was that item 8, I thought it could be taken up, I think.
Item
it
8.
could be taken up some other day. Well, was that matter where 8.5 years he has remained behind bars?
Oh, the other side is the CBI.
my lords. I thought it would have.
Did you inform him?
No, I
Oh, he's here. We'll take it up. Mr. Chan, we'll take it up.
Here, my lords, my only submission before your lordship is 8.5 years in custody.
No, last time I had asked him to take instructions on the thing, probably. Let me see the last order. Yes. You, what was your, you wanted to take instructions on his submission that, about interim bail?
Your lordships, there is no application for interim bail filed. If an application is filed, only I can file a reply in the form of an affidavit.
What? The application is not
Lordship,
needed?
the conduct of the co-accused is absolutely, your lordships will be surprised what they are doing. I can't tell in open court. I want to put everything in affidavit, and if possible, I'll give in a sealed cover, your lordships.
All right, then you file an affidavit? You file an application?
My lords,
You file an application, we consider. Fair enough, because he cannot be, he's appearing for an agency.
So,
he cannot make a submission like that.
Saying that I'll file an affidavit.
All right, file an affidavit so that he can give a reply either way. The court will accept it or not, in the matter. The fact remains that you file it as early as possible so that copy can be given.
I will give a copy. If I have a copy on him, then I'll.
If you give a copy beforehand, it will be easier.
I'll give him a copy.
All right, Mr. Naik. If he files any IA and serves a copy on you, get instructions on that. Senior counsel appearing for the petitioner submits that he would file an interlocutory application seeking interim bail and requests for some time for such purpose. Let this matter in the week commencing 3rd May. 6th May. If any be filed in the meantime after serving copy on the other side.
A week after 6 May, because it at least takes 2 weeks time for approval, your lordship, because it comes from the Calcutta. This case is registered there.
No, I will file this application by next week. I'll give him a copy. So let him.
He will get 2 weeks in the meantime.
No, so after he receive, I need 2 weeks time.
Oh, yes, we will receive it.
By next week, this week I'll give you.
If you are unable to obtain instruction by 6th, we'll adjourn for 1 more week. Yes, or not? He has been in custody for 8.5 years, so it's not a. Yes. Oblige.
Item 52. May I please, ma'am? Here the charge sheet submitted under section 302(120)B,
yes,
34 IPC and custody matter from 26th April 2023. And in the meantime, I was kind enough to grant bail to one co-accused Akash Patra, which is criminal situated matter. So far, the prosecution case is concerned. And so far, the allegation is concerned, 3 persons were coming in the motorcycle, and one was assaulted, and last night he was succumbed to death on the spot manner. And those 2 other persons were in the motorcycle, they have not identified anybody. Now, the only materials is that 2 persons on their, while leading to discovery, they have disclosed the overtact of the present petitioners, and accordingly, the petitioners are now in custody. And Akash Patra, who has been granted bail, is similarly situated because his name also came to liability in view of the statement number 27 given by 2 other co-accused, not by the petitioner.
FIR is unknown.
FIR unknown, someone. And the 2, but we see the last 2 pages of that particular, they are the statement of 2 co-accused persons were there, and they are, my lord, one Vivek Sindria and one Pintu Bahadur. In their, before the police, they have given their statement to this extent that I, along with the petitioner.
Where is the order in respect of the co-accused?
That is BLAPL number 10286 of 2023.
It has come.
That's
10?
10286 of 2023. Akash Patra.
You have a copy of that order?
That's it, like
बाहर करते खुली बाहर करते.
But my lord, he is not coming on the similar footing.
Because
all were there.
But the specific role of Akash Patra was that he was watching the movement of the people. But the assault part is against the present petitioner, Ajit Sandra, who is the principal actor, because he has engaged all persons. Ajit Sandra, Pinto Bahadur, Vivek Sindria, Tupuna Kumbho, and Jabar. These persons were they have assaulted. And the relating to Akash Patra, his role is only limited that he is monitoring.
But who has said about his implication? Because the FIR is unknown.
If you are those persons who are accompanied with the deceased, they have stated, my lord, that
ଆମେ କାହାକୁ ଜାଣିନୁ
କିଛି ପିଲା ରାସ୍ତା କଡ଼ରେ ଦେଖିଲି ଯେ ଗୋଟିଏ ମୋଟା ଠେଙ୍ଗାରେ ମୋର ଗାଡିକୁ ମାରିଲେ ସେଇ ସମୟରେ ମୁଁ ମୋଟର ସାଇକେଲ ଚଳାଉଥିଲି ପଛରେ ବସିଥିବା ଏକଲବ୍ୟ ଜଗତ ଓ ତୁଳାରାମ ଜୟପୁରିଆ ସେଠାରେ ମୋଟର ସାଇକେଲ ତଳେ ପଡିଛି ମୁଁ ଭୟରେ ଜୋରରେ ମୋଟର ସାଇକେଲ ନେଇ ପଳାଇଲି ସେଠାରେ ଯୁଗଳ କିଶୋର ଜୟପୁରିଆ କୁ କହିଲେ ଯେ ସେମାନେ ମିଶି ଆମେ ଘଟଣାସ୍ଥଳକୁ ଆସିଲୁ ସେଠାରେ ଦେଖିଲୁ ଯେ ତୁଳାରାମ ଜୟପୁରିଆ ରକ୍ତ ଜୁଡୁବୁଡୁ ହୋଇ ପଡିଯାଇଛି.
He has not named anyone.
No, no one has been named. But investigation depends on the kind of see the charge sheet matter. Charge sheet.
Learned counsel, the petitioner has very kindly given a copy of the police papers.
entire thing बराबर
Yes, yes. The court is grateful. Charge sheet कौन अच्छी?
My lord, last question. That it is further law that. Last question. And the accused person Ajit Sandra knew that they would return in late night after celebration of the birthday party. In order to execute their plan, Ajit Sandra placed the accused persons Akash Patra at the convert point of Jamera and Mahakupta village to provide information regarding return of the deceased.
No, the court was in scores ta court. Source ta court. How did the IO come to this finding? Who has said it? Some witness may have said.
Witnesses no.
No, those who is accompanied with the deceased, they have not stated anything.
Vivek Sindria and
Well, how did their names come to the picture?
Because Ajit Sandra is the first he was apprehended.
Ajit Sandra.
Ajit Sandra, present petition.
So, all right. He was apprehended on what basis?
He, on his statement, he has apprehended on basis.
That is the problem.
And that the wooden, that the wooden lathi, it was seized from another co-accused that Vivek and Pete. That was seized from them. They have also taken the name. Totality is on the basis of confessional statement. But the role is different. He is
No. It's all right. We'll pass a separate order. The petitioner is in custody since
26/4/2023.
26/4/2023 in connection with such and such case. It is alleged that the petitioner hatched a plan to kill the deceased. He had a quarrel with him.
due to election
With whom he had
Previous.
a previous dispute. Stop. On the date of occurrence, while the deceased was returning to his house after attending the birthday celebration of his friend from a different village along with some friends, the accused persons restrained them on the way and assaulted them by means of deadly weapons, causing fatal injuries on the deceased. Stop. No one has been named in the FIR. In course of investigation, basing on inputs received from different sources, the petitioner was taken to custody. Stop. He is said to have confessed. He is said to have confessed before police.
यार confession नहीं है
हाँ कोई नहीं
यार नहीं है
अपन कोई नहीं
No. Let me see the last two confession of two persons.
Vivek Sindria.
Yes, Vivek Sindria and another person. Vivek Sindria and Pintu Bahadur.
Basing on the inputs received from different sources, petitioner was taken to custody. However, this court finds from the materials available in the case diary that the petition that no one has stated about the presence of the petitioner, save and except two of the co-accused persons. Two of the co-accused persons. So, 27 ଟା ଅଛି ଆଉ
27 ଟା ଖାଲି ସେତିକି
which they disclosed in their section 27 statements. As such, there is no admissible evidence to show the involvement of the petitioner in the alleged occurrence. Taking into consideration the above facts, as also the period of detention in custody, I am inclined to allow to pay for bail. Yes, no.
53 ଟା ବି same other co-accused.
53 same,
ଆଜ୍ଞା.
same.
Item 54.
I mean, please, my lord. This petitioner and
Is there got a previous order in there? This court would like to know the specific allegations relating to the contact of the petitioners with Pakistani nationals, and secondly, the total financial involvement.
Madam.
Have you obtained the instruction?
Yes, sir. That total entire records that engages 1,500 pages. That is preliminary charge sheet, CDR, all these things. But I have tried my best to that some of the documents of instruction I have received. Before that matter, I have a draft. Question can you see that that three recharge box, right? That all are the member of that three recharge box. Is the matter relating to pre-activated C. Then I can see the first is a Pradyumna Kumar Sahu. At the top of the list, that guy. He is the manager of the geophone. His role is that he supplied the pre-activated seat to Pathani Samant. That Pathani Samant is the main person. He engaged two persons. That Saroj Kumar Naik belongs to Noyagar. Another one is Somyaranjan Patnaik, that belongs to Jasper. Their role is that they will bring that pre-activated SIM and supply to the Pathani Samant. Pathani Samant SIM, it was sold to outside state and even outside India. How he came with picture matter? He was father after India. That matter one Hamid matter can see that left side I have.
Yes.
Hamid. He is a Pakistan member, Pakistan
national
member. He is an intelligence officer. He has been linked with ISL. He has the SIM which was activated by that Pathani Samant. To that SIM, some of the photographs of the defense photographs, it was sent by one of the accused. So that Hamid has directed to Abhijit matter that Abhijit Sanjay that you paid some money to Pathani Samant. On his direction, that Abhijit Samanta, he has sent money to Pathani. And in that matter, that Pathani Samanta, that has amount is minor. That is small amount, that 550 rupees was transferred to his account on the direction of the, and more than 3 lakhs was transaction was there to the wife of the Pathani. And that my lord, Abhijit Sanjay, which belongs to a Maharashtra, in person, he sent money on that, because he has directly with that Hamid, that Abhijit Samant, he has directly with the Hamid. And though the SIM was, the SIM was activated by the Pathani, and some pictures were sent to that SIM was found in Karachi. So Hamid told that this Pathani Samant belongs to our people, so you send money to Pathani Samant. So that is, which is under investigation, how that 3 lakhs rupees come to the wife of the operating. So there is specific allegation of Pathani and Abhijit matter. Against other persons who matter, Pradyumna Kumar Sahu, he only supplied. And Somyaranjan Patnaik and Saroj Sahu, they have appointed by that Pathani Samant, they only supplied that pre-activated SIM. Another person matter, that is Pritam Kaur. Pritam Kaur matter, he was engaged by Somyaran. His role is specific matter, he purchased SIM from the Somya in rupees 4,000 and sold that SIM in outside the state in cost of rupees 15,000. His role is specific, that he only purchased and sold. But this Pathani and Amit and Somya, Saroj, Pathani and Somya, they have created it. That is only.
They have link with that Pakistani national.
Pakistan link is matter, that is Pathani has directly, because those SIM was activated by the Pathani. Obviously, they were engaged by the Pathani. See, pre-activated SIM they have supplied to Pathani. Pathani SIM was found in Karachi. And to that SIM.
What is the role played by these two petitioners then?
Yes, there is no, only they have Pradyumna, that Saroj and Somya. They have no specific link with that. They are only work for the
Pathani Samant.
Pathani.
He is the main accused.
He is the main.
He is not before us.
And Abhijit Sanjay. They are the main.
Pathani Samant is not before us.
Yes, Pathani Samant is before us.
Sir, I am stomach.
Pathani connected matter. 9089 of 20.
Yes. There are 3 applications. One is Pradyumna Kumar Sahu. One is Pradyumna Kumar Sahu, your client.
Yes, sir.
Pathani Samant Lenka and Saroj Kumar Naik. Then Somyaranjan Patnaik. Abhijit Sanjay. Pritam Kaur. Where is Mr. Chand? Mr. Chand was here. So this is
the entire scenario. So Pathani and Abhijit Sanjay, they have link with that Pakistan agent. Hamid.
Where is Mr. Chand? He is one of the, he is appearing for Abhijit Sanjay and also for Somyaranjan Patnaik.
Pritam Kaur has no role, because Pritam Kaur only purchased in rupees 4,000 and sold that SIM. He has no link with these persons.
Yes, Mr. Chand. As it appears, from whatever the State Council has prepared a very good chart also, what I find. So what it appears, there are 2 main accused persons having link with ISI or Pakistani intelligence. Pathani Samant Lenka and one of your clients, which is Abhijit Sanjay Jambure, alias Deshmukh. Others do not have so much of implication. Other applications can be allowed.
But so far, my 2 clients are concerned.
It is the one is Pritam Kaur. He has fairly submitted that he has not much role to play. He collected SIMs and sold it at a higher price. So he can be considered. But this Abhijit Abhijit and this Pathani Samanto.
Yes. So far, Pathan Samantha is concerned, my lord, I am ready to file to affidavit and let them also show a single document that I have any role. I do concede that in suspecting my or this Pathani Samantha role, Pathani Samantha was taken to Bangalore, sorry, Pune. There also he was kept in a hotel, and the entire money has been bear by the Pune police matter for 5 days, and he was left out. So no, absolute no case at Pune. It is their specific submission that Pathani Samantha is involved in a particular case, bomb blast case at Pune. But absolute no case. I am ready that if my kind enough to allow me, if I have a single case at Pune, I might bail up.
Not a question of Pune.
That there is bomb blast case.
You are linked with that Pakistani national having link with who is an intelligence officer of Pakistan.
No.
So far that
Sir, kindly see the charge sheet number page 31.
Of your application.
Right.
charge sheet is charge sheet though.
Charge sheet तो नहीं.
Sir, file
Last time we have
file charge.
enter the दिया
Page 31. Para second.
वैसे डाल तल देखिए.
Yes. Please. Sir, para second. Para second, sir, 8 porchi. I arrested. That means Abhijit Jambure. Abhijit Sanjay Jambure.
para से कितने कौन
during investigation. Sir, during investigation आरंभ हुई जी. से मझी पर्सन नु पडुची. I arrested. Abhijit Jambure was arrested during investigation. Wipro technology sir eta bola. I prepared this disclosure statement of Abhijit Jambure in personal official witness provision 27 Evidence Act, seized the printout and a screenshot, 285 sheets of WhatsApp and 37 sheets of ATM transaction was Abhijit Jambure. And I arrested on 29/6/23 and forwarded to this court. During investigation, it is evident from the WhatsApp chat accused Abhijit Sanjay Jambure as per the direction of Hamid. He was directly connected with Hamid. There is no connection of Pathani. And he, PIO, Pakistan intelligence operative, has sent money to the accused Pathani Samant Lenka in Petition Bank, Airtel Petition Bank. As per his direction, the sum, sort of cash rupees 5,400. It is also established from HDFC Bank statement of accused Abhijit Jambure. When 5,400 rupees come to the Abhijit Jambure account, and that money was transferred to the account of Pathani Samant Lenka from the Hamid. And Pathani Samant Lenka has no direct relationship with the Hamid. Thereafter, the matter of rupees 3 lakhs. It is the bank of HDFC. 3 lakh bank, sir, page 32. 3 lakh rupees not come from the Pakistan to the account of Pathani Samant Lenka. It is verified the Bandhan Bank statement. Sir, second. It is verified the Bandhan Bank statement of the Pathani Samant Lenka. His wife Sashikanta Mishra, it is found approx 3 lakh rupees credited from the account of Sashikanta Mishra in the year of 2021.
From to the account of Sashikanta Mishra.
Again. It is Bandhan Bank account. It is the account of Pathani Samant Lenka. That has been transferred.
It is the account of the wife of Pathani Samant.
To the Pathani Samant Lenka. That money has not come from the Pakistan. 3 lakh tanga Pakistan sir asala. Only 5,400. That is the matter. And that SIM, the SIM was activated by the Pathani Samant Lenka. How a SIM company will activated by the KYC of a certain person. And which that SIM was which name? That was not prescribed in the charge sheet. Se SIM ta, jo SIM ta कहउचन Pathani Samant Lenka activities करथिला, se SIM ta activated. Suppose I purchase a SIM giving my KYC, the company will activate this SIM. So if it is operated in Pakistan, and which name was the SIM? How can the Pathani Samant Lenka will activate the SIM in own name? But this SIM was operating which name?
That is not described in the fact. So Pathan Samanthalanka has no direct relationship with any Pakistan.
All right.
That was reactivated and it was name of a Riksha Pulara Kubanga. That's it.
Anyway. That's all. Hearing concluded, judgment is out. Ita tanko de diyo. You give this case diary. Case diary or charge sheet?
Only instruction I have received.
So that instruction along with the charge sheet.
Entire case that is more than.
I'm not asking for the case diary because it is voluminous, but you give at least give a note along with the relevant documents at least. The London State Council submits that the case diary is voluminous, running into more than 1,000 pages, and that he may be permitted to submit a gist in the form of a short note. Let the note be filed within a week.
Last occasion, I have given the entire copy of the charge sheet to my lord.
If not, then you give another copy. Xerox copy. Hearing concluded, judgment is out. Yes.
I beg pardon, my lord. Item 57, my lord. 57, I pray for 2 weeks after, my lord. On behalf of Mr. Mishra, he has informed me.
57?
Yes, ma'am.
Weeks after, yes. Item 60? Check.
Next time 61, since there is a petition from Region, Lordship may peruse the petition and delete my name because
we'll take it up tomorrow. Tomorrow I'll delete.
day after.
I mean day after tomorrow, yes.